Sorry, because of the administrative exigencies, I have to sit late. Yes, pass on all the memos. Please pass on. Please pass on. Please. Whatever, review of whose jurisdiction. Then they'll have to write to an administrative department for constitution of a bench if one of the judges is available. No. Sir, we'll consider. There is already a constitution of larger bench. Let us see. Don't worry.
Illegal detention of a minor child.
We pass on the memo. Why you exhaust your energy? Conserve it, exhaust on the day when it will be listed. No senior can mention.
I'm saying that one item number 32 is a tender matter. My client is no more. It is so well to it was.
Okay.
That's
For that you have come.
That's
You could have sent your junior.
That's not the reason.
No. No reason. Yes, call the list.
44 also my rental is being 44. And he wrote technical one, sir, 17 also.
Both of you agree?
5170.
42 withdraw, 44, 70.
That's it directly to take instruction.
Yes,
70. Yes, call.
Item number 1.
in the outskirts society, in the present public interest litigation, made for challenging the action of the opposite party operators in not initiating any proceeding for erection and demolition of the unauthorized construction by the opposite party on for a government, which is recorded as Gochara, the grazing field for the cattle.
Yes, what are you doing? Have you taken the instructions?
Some instructions in logical get of this 1 week that will be given. There was excess goated land and the land has been settled, it seems.
Okay. So you do one thing is you file an affidavit disclosing the entire thing. If you have already initiated a proceeding for conversion, initiate that. There is no difficulty.
Next Wednesday, you know.
By this time, you will be able to file the affidavit.
By next Wednesday, not this Wednesday.
Wednesday week. Say Wednesday
Next
week.
week, Your Lordship, Wednesday next.
The OP7 is going
Yes.
on
The instant applicant, the writ petition in the nature of a public interest litigation is at the BS top, the registered society. If the Rome was not built in a day, even a construction cannot be built.
Item number 2.
If it is illegal, it will come down. Don't.
Regarding the illegal opening of the IMFL offshore.
We received instructions, Your Lordship, that they had filed for a shifting of their shop, Your Lordship.
Fact number 5 is already applied.
And that has been processed, Your Lordship.
There is no question.
They'll shift out, Your Lordship. The authorities have started.
The relief is virtually allowed.
That is what is there.
Yes.
Another area.
You are not pressing this.
With that, the instruction will have dispatch of the writ petition.
There's already
Therefore,
established.
without delving to go into the intricacies of the maintainability of the public interest litigation.
Paper is short time because every instruction is married.
Who are you?
I'm a petitioner.
Yes, he wants time. How much?
What's the next Monday?
On the prayer of the learned advocate for the petitioner? Exactly. Next.
Item 4.
I don't pour my lord. Proposed to take interest rate or precipitate bills. You know, also to grant them some time, but I find in the conflict, my lord, there is a petition for intervention. I have not received any copy.
Who has applied for intervention?
I am applying for the petition.
Who is the intervener, proposed intervener? Who has applied?
No name is there, but in the conflict at flag A.
An application for intervener by some Manoj Kumar Pati. And who is the advocate representing him? The name of the advocate. Oh, he's in person or what?
Because he may be in person, so you know, what Pandi is one of the advocates.
In person. What to do?
We are also in call. Very for
To take further instruction. They got that further instruction. 24.
Item number 5.
Coming up that issue of e-tendering website. The last provision was not instructions.
So you have to appraise with regard to the technical glitch that
Yes, no, technically matter.
there was.
And in the meantime, it's the instruction, the tender is cancelled.
Oh. Now what to do?
Both the matters.
Both the matters has to go. Okay, one page order, not the lengthy one. Instruction you quote the instruction. Huh?
The subject tender has been cancelled as.
Put that portion on.
Yes.
Yes, next,
Item number 6.
become instructions. Dismiss.
Six, where the petitioner is seeking a direction to the opposite parties members who to four to remove a mobile tower which has been installed on the land of the opposite party number 5.
Who are you, sir?
I am one of the inhabitant members of Goldbhaga village.
Yes?
I am one of the inhabitants of Goldbhaga village.
Acha. How far your house is from the tower?
Just adjoining to people.
So they could not install at your land, they installed at the land of opposite
Adjoining
party.
land.
You wanted that they should have installed the tower in your land
No, madam.
so that you can get a
No, madam.
compensation and the money.
No, madam. Our preference is that the tower should have been installed, madam, at some other place where no persons are there. Here, madam, nearby they have. They have
Tower is used by the inhabitants only because of their use of technological this equipment, technological equipments.
But there is
So-
a danger to life and property.
Well, how? Show us the study which has been done.
Yes,
Show us from the documents.
madam, earlier this petitioner approached this.
I am asking you, show us the research data, show us all those documents that the installation of a tower is hazardous to the life and it will diminish the length of a life or it will cause very deadly diseases. All these things, the study reports, everything. In a city, we have seen a lot of towers are there. Show us.
Madam, here, madam, the opposite pattern 3 has, madam.
Sir, when you have come, then you'll have to make out a case that why. Mia, I do not want that the tower should be installed near to my house. That does not mean that you have a right. You should show that what is your legally enforceable right. First thing is constitutional right, the fundamental rights guaranteed right to life. How it impedes your right to life. You have to show.
Madam, the Tahsildar has called for
Mr.
the
Counsel,
reports.
You are
The
not
Tahsildar-
understanding.
Mr. Counsel, the Tahsildar is proceeding with the matter.
No, madam, he has not proceeded.
He has posted it to 31st August
He has
for report and further.
Brother, we
2021.
very strict on the PIL. This kind of a PILs, if they start doing it, then it will be a complete abuse of the power of the.
Because we
There should be a pleading to that effect. You have
Yes, madam, I have pleaded.
show us the empirical data which is there, which shows that what it can cause injury to a life or a person. What? There must be an empirical data. What is those empirical data? Show us. We are saying will not do. You know, any observations which is made has a cascading or a lot of impact throughout the country. It is not a one tower. It relates to, I think, the millions of towers which are installed throughout the country. You have to make out a case.
Madam,
You have not done a study, you have not done anything, and you have simply come adjacent to my house. Not good for my life. How? There is no pleading, sir. You are coming, sir. Is it not your duty to plead something? We have to go, we have to accept it. Without that, how the fundamental rights of the peoples of the country is infringed by such installation of the towers. There must be a study, must have been, I'm sure. Then whether it infringes your fundamental rights, right to life, does it? We have to arrive at the decision, sir, on the basis of the materials before us. No material is coming and you are coming and arguing PIL without pleading anything.
No, I have mentioned that it may cause.
How? Now the question is how? Let us go to extreme case. A telephone line is is installed near to you. You say hazardous to my life. This is what you perceive. Is it really hazardous to the life? There must be some study. There must be something. Some documents must come before the court.
The experts can say matters.
That is the only thing. You have not pleaded anything.
I have only mentioned, my lord, that the art of plot number 736, in which the mobile tower has been installed, is handy and not so hard.
So it may fall.
That's
So they must have done a soil test. Those will come.
that.
And if they find that the soil is sufficient enough to cater the load of the tower, then who are you to object to it?
If everything is, my lord, all right, but there is a clear, my lord, non-compliance of direction of this honorable court.
What?
My lord, may kindly see page 24 annexure 5.
Yes. What that compliance? What is the not?
That is, my lord, the order passed by this honorable court on 3/2/2021.
Yes.
Giving direction to the opposite part number 3 Tahsildar.
Is it a PIL now again?
Yes, madam. This
Is
is
it-
PIL.
Again now,
Again.
suppose a direction is passed under the public interest litigation
Well,
upon an authority to do a certain things. If the authority is not doing anything, then PIL. Or it is an inaction on the part of the authorities in not complying the order of the court. Then it becomes a writ of quo warranto or a mandamus. Is it not? Then how the PIL lies still?
Some other day, madam.
Now, henceforth, I will not open my mouth. Open my mouth through the dictation of the order, nothing. The moment I put a difficult question, it gives encouragement to an adjournment.
No, my lord, sir.
Let me go through it, let me read.
No, as because, my lord,
Henceforth, I will not open my mouth.
no, my lord, as because, my lord, earlier PIL was filed. So,
That is what I am saying. I have been experiencing these kind of things here, which is really unknown to me.
Mr. Foster, the second description of the section was. Okay.
Here, my lord, no, selection cost, my lord, not maintainable.
There in the first.
Here, my lord, in the meantime, the tower has been installed. In the meantime, the tower has been installed, but this one will go directed to here the parties and
Or here, the I think the statistics that we have gathered before filing this PN, showing that there will be health hazards and there will be danger to the public health.
my lord, I will collect.
Sir, that homework has to be done before filing a writ petition, not during the course of writ petition. If the manner of filing a writ petition and everything is better. What transfers and during the course of argument, you will go on adding those pleas, which are lacking in the writ petition. Is that what you have learned in your career?
What to do, sir? On what basis we will pass it? Record the reasons. These are the things which you have disclosed. What we will record? Tell us that what we can record.
Well, I only
Please
tell
tell us.
that as because there was a direction of this one will go to hear the parties and take a decision.
Then the question, then we'll have to say that we are entertaining the public interest litigation on this facts.
Well,
Correct? Is, according to you, is it a correct proposition of law? We can't pass an illegal or wrong order. At least consciously, we can't pass. In an unconscious mind, we can definitely, nobody can claim I am not infallible. Even a judges cannot claim I am not infallible. Everybody is susceptible to commit some errors. But knowingly nobody commits error. Then tell us, we will record. If this is the consideration, good ground, legally sustainable, we'll record. You know, can't be. How can we record?
the prosecutor is not acted upon the.
Is it a PIR? Then again I'm saying,
Yes, ma'am.
is it a PIR?
Yes, ma'am.
According to you,
Hmm.
then I think let me deliver a judgment on that what does PIR mean? Then it will impact, at least to my estimation, thousands of the PIL applications frequently coming in the docket of this. It is not coming from Article 226, nor coming from Article 227. It is a judge-made remedy. Where is under the Constitution the concept of PIL? Not even a word you will find in the Constitution about the PIL. Neither it is mandamus, nor it is quo warranto, nor it is certiorari, nor it is habeas corpus. It's a judgment remedy since 1980, I think, started. How can you say it's a PIL? Is to remind the sovereign of their constitutional duties, either appearing under Part 3 or Part 4 of the Constitution. If it infringes the fundamental rights, they must be reminded that they have to protect the fundamental rights of the citizen. If it is within the directive principles, Part 4, then they have to be reminded. Can never be misused like this. Bhagwan Mukti Moksha judgment, read that, what PIL says. Just early 80s. No, sir. So clear abuse of the process. The public interest litigation
Please, my lords,
Yes, sir.
may I submit, lords? Lords, this is a public interest litigation. In page 31 is my prayer, wherein I am seeking a writ of mandamus for a proper sanitary landfill site at Bhubaneswar instead of the present one. If your lordship could have a look at page 31.
This master might have it is showing that it is a PIL and the copy. The Imperial Union of British Party, I have not received any copy. Let them serve a copy.
Oh, I'm so sorry, my
I
lordship.
have not served the copy, sir.
My lords, I'm sorry, it must have been sent to the Advocate General, the note says. Lords,
Where, no, he's representing the union. Union is a party here, Union of India.
P8 member.
I'm sure my colleagues are there, they may have, because
Why
I
you
have
have not
it
served
pro
the
bono
copy?
from Delhi, plus my
As
colleague.
per Union of India,
Main-
along with.
Main prayer is against state government. And
Then why you
It's
have?
all right.
Then they delete the name of
If you
the
have implemented, will you not serve a copy on at
Yes,
least?
yes, it should have been. It ought to have been. My lord, I am agreeing. It ought to have been.
Why you have implemented in the
sir.
party?
It ought to have been, my
If they
lord.
are
I'm
not
sorry.
interested, then it's a
I'm
misjoin.
sorry, sorry. My lords, I'm so sorry. It ought to have been. The Union of India ought to have been, sir.
In course of this week, sir.
Kindly give a date. I will do the needful.
In the next week.
Right.
I'm so sorry.
Is-
Item number 8.
Appearance memo on behalf of. The
last occasion, the state had submitted that it didn't have copies, so I had served a copy and the rest of the instructions.
Your Lordship. In this matter, the license has already been settled, Your Lordship. And this petitioner had, in the previous matter, Your Lordship, which also had challenged the same sale notice, Your Lordship. That has been dismissed by the Honorable Court, Your Lordship. And in that writ petition, the main prayer was for against the demand notice, Your Lordship. This Honorable Coordinate Bench, this Honorable Court held that they have to deposit 50%, and on depositing of 50%, there will be no coercive action. Till today, they have not complied with it. Another case was also filed, Your Lordship.
Learned counsel is submitting out of her hand.
This is the third case, Your Lordship.
Main matter is still pending.
Yes, main matter is still pending. I have complied with the
Your
interim
Lordship,
orders.
in the interim application, the sale notice was
Lords, I have
Yes.
complied with the interim
You
orders.
should be reminded of the proposition of law.
yes, Your Lordship.
Finding made at the time of an interim application disposal is mere a prima facie and a tentative finding, having no bearing on the, at the time of finding.
Yes, Your Lordship. Previous to
This is, the writ petition is pending. In that writ petition, we court will not be swayed by this.
Yes, Your Lordship.
Decided.
Before that also, another writ petition was filed demanding, challenging the same demand notice. Your Lordship, I can give the number.
Disposed of.
That is disposed of. It was directed that his
Your
representative.
Lordship may see their own IA.
Again, he was served with the
Or
demand
you,
notice.
then you want to take advantage of order 222.
My lords may see their own averment in the IA
Sale.
filed in the WPC
Simultaneously, she's raising a
76.
preliminary objection of the maintainability.
Yes,
That is her right to begin.
yes.
So let her.
Okay.
Where is the original relief? Where is the relief in the last writ petition?
Lords, I have annexed that interim order here.
WPC number 17923 of 2023.
Where is that? You have the copy
Oh,
of,
Your Lordship,
there is the relief scheme, there is.
I have annexed that order, my lords.
Receive the information.
Sir, when order 222 has to be applied. Yeah, that is a, one has to look at the relief claim,
Concede.
not the order.
I concede in the order the relief claim is quoted.
Sure. That it is.
Your Lordship may kindly see
Which one? That the entire relief claimed in the writ petition.
annexure 7 at page 26.
Yes, quoted. This is the first writ petition.
No, this is the second writ.
First writ petition is also saying that the same relief.
No, there, my lords, the interim order I have quoted at annexure 3, my lords, I have given the interim order. That is at page 19, my lords. I have given the interim order which was passed.
No, madam, it was not in relation to that. They have asked for the demand notice
Yes, your lordship.
required.
Yes, your
And that
lordship.
was in relation to period between 22 to 23.
23.
Yes, your lordship. That demand notice, they didn't, that was there that they considered their representation be considered, your lordship.
But in the extended petition, they are challenging which order?
The challenge.
I'm challenging the sale notice.
Sale notice.
There is the
Sale notice is,
annexure.
that is annexure 1, my lords, page 11.
This has already been, that has already been settled, your lordship.
No, settled is the same notice is given, that is on 19/6/2025. And they might have settled it, but they wanted to challenge it on
Yes, your
various
lordship.
grounds.
In this writ petition, the second writ petition, they were asked, directed to deposit 50% of the demand
It's on
notice.
facts. It must be objection. It must be a pure question of law. Or somehow intricately related to something. But here, if they have not complied, you must have taken a council decision. Is the actual aspect. Yes, what ground they say has to be passed.
My submission is this, my lords. In 2022, my lords, a demand notice was raised, which I challenged in WPC 7639 of 2022. When I challenged that, an interim order was passed at annexure 3, which I have given at page 19, my lords.
Yes.
This court directed, my lords, that on my making a deposit of 50% of the demand, my lords,
Correct.
no coercive action will be taken and no coercive steps will be taken to recover the remaining balance.
Correct.
That was the order passed.
You deposit the.
Yes, my lord. Your lordship may see this IA, my lords. This is an IA, say page 4, para 4. This is an IA filed by the state in that application. At para 4, kindly see their averment.
No.
Lords, I have deposited that 50%, which my learned friend is saying has not been deposited. This is their averment in the IA, which they have filed in that writ petition, which is pending. And now my learned friend is saying that we have not complied with the interim orders. Then, my lords, in the next year, my lords, another demand was raised, my lords. When that demand was raised, that is at page 25 of the brief, my lords may see. 25 of this brief. 24, it begins, annexure 6. Letter dated 9/27, dated 17/4/23, show cause notice. That though you are directed to deposit area consideration money of your OS main and branch shops relating to 22-23, you have neither deposited the same nor taken any steps for renewal of the shop for 23-24.
Correct.
And then they give the details of the demand at page 25. 66,68,891, my lords.
Correct.
This was challenged by me in WPC 17923 of 23.
Correct.
The order is at page 26. My lords may look at paragraph 3 of the order. Present writ petition filed with the following prayer. That this honorable court be graciously pleased to admit the writ petition.
No, I understood. I have.
Yes, my lords. Now, this was disposed of, directing the excise superintendent to consider. Lords, he has not communicated anything to me, my lords. Before that, my lords, my representation that 3 branch shops are not functional and this money can be adjusted from out of the money that I have deposited already. That was sent by the collector to the excise commissioner. Excise commissioner told the collector, you decide at your level. They didn't decide anything. The next year they didn't do anything, my lords. This year they didn't do anything in the month of April, my lords. Now suddenly they issue a sale notice without any intimation to me that my license has been cancelled. They issue a sale notice. So I challenge that in an IA in WPC number 7639 of 2022.
That was listed when your lordship was not there. It came up before the bench consisting of Justice S.K. Sahu and Justice Raman. So their lordship said that you are expanding the scope of the writ petition. So they did not interfere with that. So I have filed the present writ. I think my lord, his lordship Justice Raman remembers. The entire whole thing, Milords, arises out of that demand, Milords.
I'll file an affidavit today, if your lordship let it come next week.
After tomorrow.
On Thursday, your lordship, on Thursday.
You have already settled the.
Yes, your lordship, I have.
Yeah, after tomorrow.
That your lordship may kindly look at annexure 8. My lords may.
Thursday,
10. On 17th.
Thursday or 7th.
17th of.
Yes, Thursday is not. No difficulty.
Your lordship may kindly look at annexure 8 to the IA which I have filed.
Not required, sir.
No, it shows that he has not yet complied with the deposits, Milords.
It just states, later.
So if she is fine,
Initially, a privilege of which was based on the methodology of the issue. But after.
Item 9.
may I pray one thing, Milords? Can the two other writ petitions be called along with this item?
Don't make it more closing. Yes.
Item number 9.
The writ petition challenging the action of the opposite parties in rejecting the tender without considering the documents that have been submitted by the petitioner. The lordship has page 90. Page 92, your lordship. 92. Lordship, the bid rejection.
Who are you?
Lordships, I am a petitioner who is Sanjay Kumar Agarwal.
Yes.
Sanjay Kumar Agarwal.
Yes.
Lordship.
Serial number 1.
Serial number 1. Your lordship, the ground for rejection is that as per Annexure 1, Schedule 3, Clause 7 and Clause 112 of DTCA, I've been rejected.
Yes.
I may take to your lordships to Clause 7. Is that page 41, your lordship? 41.
Yeah.
Lordship, this clause, clause 7 at the top of the page, your lordship. Lordship, this clause, it states that I have to submit an MOU with an electrical contractor for execution of the electrical work. Lordships, at page 95, I have submitted that particular MOU. It has been prescribed as per the DTC. Yes. Lordships have page 95.
The eligible registered electrical contractor.
Lordships.
The second party is in the registered.
Lordships. Page 95 is the MOU, and the details of that particular electrical contractor is at page 143, Your Lordships. 143.
Yes.
Lordship. The contractor name is Shivani Infrastructure and Suppliers, proprietor Yeshugava, and
Approved by the chairman, GMPO.
Lordship.
Of 2019.
Lordship.
Yes.
Lordship.
So the rejection was solely on this ground.
Lordship. And one more ground.
Where is the rejection? Page.
Lordships, page 90, 92.
Then where is the clause 112 million of the
Lordship, at page 58. Fifty-eight. Clause number E.
of the machineries or equipment.
Lordship. The schedule is at page 84, Your Lordship.
Page?
Page 84. Lordships, for your Lordship's convenience, I have prepared a tabular chart with regard to this Schedule C and what are the relevant page number of the machinery which I have submitted.
No, sir, you must have, but unless we look at that relevant paper, how do we understand clearly?
Lordship, that's
Don't
what I.
worry, you just refer it, then I will keep that.
Lordship, it would be convenient. I'll just, the page numbers are also highlighted in this. I'll
You
also.
don't know me. That's a difficult.
Lordship.
As you refer. Schedule C, you have said the complete mixture, one number, complete vibrator, two numbers, and then you have said.
Lordship.
You said.
Lordship, what in the particular bid document, I have submitted what is much more than the requirement.
So that you are giving more.
Yes, but still then they have rejected my bids on this particular ground that I have not submitted the bid documents. First is the electrical MOU, and second is that I have not complied as per the Schedule C. Whereas the fact remains is that Lordship has submitted both of them. And even the list of plant and machinery.
That is the clear intra projects. It's part of.
And this,
Very clear.
no, my lord, the only thing is that this Schedule C is not part of the tender documents, my lord, which is submitted as per Annexure 3, my lords. This Schedule C does not.
Part. It
No, my
did not submit along with this.
This is not there, my lords.
Lordship, that is there. We have submitted the documents.
Then you have to show.
Lordship, that's
You
what.
must have done a e-tender. It was a
Lordship, it was an e-tender.
correct PDF format which we have given us disclose that.
Lordship.
Stand documents.
Your Lordship.
This is one of the grounds for rejection, my lord.
Produce the total documents.
Lordship, we have page 90. The portal documents, the PDF that has been submitted are there in the bid documents criteria at the bottom of the page.
Yes.
Lordships. You may see the PDF file in E4, machineries and work experience. PDF has been submitted, Your Lordships. Page 93, Lordship, at the bottom.
Is.
Lordship, that has been submitted, your lordship.
Madam,
The bid documents which they have only submitted shows that they have not submitted Schedule C, my lord.
we'll have to retrieve those documents.
Lordship,
What it will say.
Respectfully, here they have only produced their entire,
No.
in the pleadings also, they have mentioned that this is the document they have submitted during the bid documents. So this, primarily, they have to show that Schedule C.
How they will show, because the size of the file appears to be around 54.
Lordship, is that your-
If the 54, then one has to understand that what documents it will contain, the size will be.
My lord, this is the primary ground for rejection, my lord.
OS4, no, 54 or
Yes,
S4?
nine.
It's,
My lord,
And what is the KB? It's a large file.
Lordships, it is
The size of the
around
large file.
3 MB, your lordship. They're large file, more than 200-300 pages, your lordships.
This is according to copy of tender paper cost. And AMD, GST.
Sorry.
Your lordship, I will have this memo, your lordship.
And-
I will indicate the
But don't finalize it. You finalize the tender.
lordship, the LOA has been issued in the meanwhile. LOA has been issued in the meanwhile.
So not to proceed on that.
My lord, short date, my lord,
No short.
my lord, I'll produce the documents in a short date for your lordship to consider. And it's Schedule C, whether it was part of the bid document submitted by the petitioner, that is the only ground left, my lord.
Not a only ground. One, you have taken clause 7. Clause 7, yes, she shows that he has complied with.
My lord, it has to be read with clause 7, my lord.
My lord,
Clause
clause 7 is independent,
You
your
have
lordship.
taken 2 grounds.
And it's clause 1 of the tender document.
112E you have taken and clause 7 you have taken. Clause 7 talks about the experience or MOU.
MOU.
Which they say the MOU has been submitted with the registered electrical contractors. Second, 112E talks about the procurement of the goods or the whatever. machineries. They have said that they have procured. What more? Can you go beyond that?
Minus 112E refers to clause 7. So minus clause 7 has to be read with clause 112E minus. If I may refer to
Where you go 112?
page 58 minus, clause E minus.
Yes.
It refers to clause 7 minus.
Where? 100?
Page 58 minus. Clause 112E minus, evidence of ownership machineries equipment as per clause 7 of DTCN minus. So clause 7 has to be read with clause 112E minus. And my lords,
Probably you do not
My lords, they have
do
both.
not understand.
and clause, my lords, if I
When
refer,
an MOU is entered into, that means that if it is entered into, then you have to show that whatever.
my lords,
And your contention is that they never submitted the MOU, and then you said that they also did not submit 112.
my lords, if I may give one more illustration from the document which is produced by the petitioner. Page 95 refers to a MOU which is executed between the electrical contractor and the contractor. Likewise, they have also submitted documents, MOUs, with respect to other works. In that document, they have mentioned what all machineries are mentioned or taken from the contractor. That at least shows a list. But in the particular MOU at page number 95 does not refer to any electrical documents which are supposed to be taken from the electrical contractor.
What?
Page 95 is the MOU which is executed
Yes.
between the electrical contractor and the petitioner members.
Sorry.
And if I take another example of another MOU executed by the petitioner, for example, at page number 149 or page 153, the document itself shows that what all goods are to be taken. For example, page 149 at page 151 minutes. Particulars of machinery.
Your lordship, my friend.
Similarly, page 153 at page.
How that is required? Your clause 7 does not talk about this.
Well, and
And
hence,
then when you take shelter under 112E, it talks about.
Schedule
That's
C.
all.
Schedule C is not there, my lords. That is, One of-
Please, as per clause 7 means, what is the clause 7?
it talks-
Please come to the clause 7. At page clause 7.
41.
Please, what it says.
Civil contractor, in order to take part in the composite tender, should enter into a MOU with the eligible registered electrical contractor having valid HTLT license for execution of electrical installation and other electrical works, and copy of the MOU should be attached with the tender. This is there, my lords. Which shall
That
be,
is as per the proforma schedule J,
yes, sir. My lord, this is there.
which shall form part of the tender.
Yes, my lord.
A copy of the electrical license should also be enclosed with the tender
Yes, ma'am.
papers. All of which need to be furnished during verification.
Yes, my lord.
Then the above MOU is not required in case of a civil contractor having valid registration in ST electrical license with the same style. So it does not talk about that you have to say that a procurement.
Yes, my lord.
And then 112 we say that the evidence of procurement of the machineries in terms of this clause 7 means the electrical contractor, that should also be produced.
Yes, my lord.
So
That
it
is,
does not say that if the MOU, it should be reflected.
no, my lords, it should be read with schedule C, which is at page number 84, which page number 84, my lord.
The schedule sheet does not describe that.
In terms, schedule sheet should have been produced or given by the petitioner at the time of submitting the bid document, my
So
lord.
this is what it says that I have given.
That's in the record, it does not.
Again, you are going square one.
My lord, that is the case.
I just thought that so seriously you are putting a question. I thought that something new, which they are not disclosing has come.
My lord, C is not the C
Sir,
document.
the question, madam, the question is whether those documents forms part of the tender document or not. He says that it forms part of the tender document. You say that it does not form the part of the tender document. Now, this question can only be decided to produce because the size of the file is also given. Everything has been given. You have to download the form, the tender which they have submitted, produce it before a court. We can't disbelieve him. If he has a document with him, it is not probable or expected that he will not submit it.
And that document itself, he is not producing the writ petition. That is the only humble submission, because my lord, that is primary ground of challenge. And that is,
Sir, he has disclosed those document in the writ petition.
no, my lords.
What
No, my lords, that is what.
is this page 84?
84 is part of the bid document, my lord.
So,
It's not the bid submitted by the petitioner, my lords.
so who has submitted this bill?
This is the,
This is the bid submitted by a third party.
my lord, this is a form which prescribes, but what is submitted by the petition?
Since my brother has, I think, taken up a brief for you. What he says is that what you really want to say, that schedule C is there with the bid document. But since the clause 112E says evidence, then in that event, in the last column, he must say it is a rented one or a owned one.
Yes, my lord. My lord, I apologize if I've not been able to convey myself properly on this. This is my specific contention that this particular schedule C, whether he has hired.
As a counsel, you have to put emphasis on the word evidence, which is appearing in clause 112B. And mere disclosure does not mean it's an evidence of acquiring those property, owning those property, or as a lessee those properties.
Only,
I think the one word would have conveyed a very strong message.
apologies, my lord. Not been able to convey myself.
Lordships, to answer that particular query of your Lordships,
Because they do not talk about what machineries. They say that whatever their evidence has to be produced.
Lordship, I'm placing this memo on record, your Lordships, with the page number showing the invoices and the documents of possessing that particular
Those are
machine.
also included in the tender.
Lordships, I've made this.
Please
Lordships,
tell me whether you produce those documents in the tender.
Lordships, that has been produced in the tender. I have made this memo.
Have you wherein you have said on oath?
Lordship, it has been under annexure 3, your Lordship.
I am asking where you have pleaded on oath that this evidence you have produced. Show us from your pleading
Lordship,
is true to your knowledge.
Lordships, at page 7, paragraph E.
Is paragraph
E.
Paragraph
E. E for elephant, your Lordships.
is
Lordship, it is submitted that as per the requirement of DTCN, what is essential is the bidder should submit an MOU with HTA or LT contractor along with the evidence of either ownership of the plant and machinery, wherein in case of lease, the ownership of the lessor over the machinery being deployed for the contract work.
where is annexure 3?
Lordship, it starts at page 93.
Is
93.
yes.
Lordship.
Show
This
me.
this is the bid submission confirmation, your Lordship. This is the bid, page 90.
I am asking you that you have also submitted and enclosed the invoices. Where is that?
Lordship,
In annexure 3.
Lordship. Lordship, kindly have this
Please
memo.
come, this document you are relying, show us where you have annexed.
Lordship,
You have annexed in the
Lordship,
petition,
and I
not
have-
annexed. Show us the page.
Lordship, so Lordship, may kindly have this memo. These are akin to the pages in the writ petition.
Sir, please, I am having a writ petition. Can't you give me a
Lordship,
number, page number? If you have annexed this document,
Lordship, it starts at page 101.
show us. Yes, I am at 101.
Lordship, this is with regard to the concrete mixture machine.
This is of 23rd of February 2017. It's a concrete mixture.
Lordship,
Yes,
Lordships, 101 and next is at 103. The requirement as per the DTCN, as per the schedule C is one number, whereas I have submitted 6 number of machineries for this particular
yes.
list.
So this also forms part of.
Was
the-
part of that.
I just wanted to know that.
Lordship, that's what you Lordship.
These
I have
invoices form part of the tender,
Lordship.
but you did not fill up the last column of schedule C. Isn't it?
Lordship, that I'll have to.
No, your own documents, sir.
That is what
Not
she started.
indicated.
That summary you have not
Page
stated.
84, you have not.
Lordship, page 84 is the DTCN, your Lordship. It is the copy of the DTCN. So. The part of the tender notice, your Lordship. Page 84 is the part of the tender.
That you filled up while filing online.
Now, ball is rolling on this. Produce the documents.
Yes, my lords, if I may
Yes, and
request,
we are staying the LOA
only one request, my lord.
or
Because,
LOI, I do not know, letter of intent.
my lord, the construction with respect to judicial court, bar house, my lord's only small request, my lord. The tender is for judicial bar house and canteen building at Kodahandi district, my lords. 1 week time may be given to me. I will obtain instructions, my lords. Personally, my lords, I don't want this work to stop because it's for a.
Don't proceed on the basis of. I think he says that you have already issued, or you said.
The LOA has been issued, your Lordship. The main.
If we start work then.
And hence.
I will
Lords, I was not aware till the filing of the writ petition. It was subsequent to that. I'll read it as a party. Your Lordship.
The day after tomorrow, I will see to it. In course of the hearing, it appears that
Another judgment against Sabri. Excuse railway is the party. Nothing such. Yes, railway. I've searched from this system. All the excuse railway, railway engineer, principal chief.
Friday.
Item 11.
May it please your Lordship. Second week, by interrupt my lunch name. So a virus is under challenge. It's a central statute. So central government has to respond and a demand in the garb of challenging the virus. A demand of 58 odd crores is under challenge, which is faced in consonance with Rule 12A of the Mineral Concession Rules of 2016. After granting due opportunity, so-called personal hearing, everything. So they have to respond. We have to also file a counter because the virus is under question. So therefore, the Lordship may adjourn it. We have to discuss.
I assume that the learned Advocate General is appearing for the state, but maybe he's also appearing for the Union of India. I don't know, but he's also appearing.
But I'm appearing. It's not appearing, but thing is this, because it's challenge the virus. Prayer number 2 and 3, both are against us. If Lordship will issue notice, then we'll file the counter. Otherwise, Lordship wants to case of
I'm quite happy if your Lordship's issue notice to them to file a counter.
Where is that? Let me first understand. What's up?
I'll say my learned friends will comment. I'll take only 5 minutes. I'll tell you only 5 minutes. Miller, I'm a miner of iron ore and magnetite. It's iron ore. Just a moment. Let me explain. I'm an I got a lease in an auction. Because all earlier leases, your lordships know, all earlier leases were terminated on March 20 by a legislative instrument. And then all the mines were let out for auction. I bought it for an auction. I paid a premium, and the highest premium bidder will get the auction, will get the mine. Now, the first year starts in July 20, 3rd July 2020 to 21 is the first year, 21 to 22 is the second year, 22 to 23 is the third year. Now, this writ petition concerns about the third year, Now, when I was given the mine, I was given a production plan, geological survey, which says that the bulk of the ore is above 55% Fe content, iron content. And the remaining mine is above 45 to 55. Fine. Then when I took the mine and I did my own geological study, I found that the bulk of the ore was below 45 percentage of Fe, and only a small portion was between 45 and 55, and a very negligible portion was above 55. Obviously, my lord, anything below 45 cannot be used in any industry which uses iron ore. It has to be beneficiated, which means a separate beneficiation industry or a plant. And then it adds to the cost. There are not too many buyers for unbeneficiated ore. There are buyers for beneficiated ore. Now, for the first and second years, there is a writ petition pending in this honorable court, in which they made a demand. My client made a proposal through council, and the government accepted the proposal. This writ is still pending, but the interim order was confined to an agreed amount between the petitioner and the respondents. Now, this is for the third year. The same grounds are raised, but additional grounds are also raised for the third year. What happened in the third year is, because I did not dispatch 55% Fe ore, because I did not have the 50, I asked for permission to dispatch the below 45 ore. The state government rejected that application. You can't dispatch because the plan says 55% ore. Therefore, you can't dispatch 45. I said, what do I do? That is the ore here. I have mined it. I have produced the ore. I can't dispatch. The dispatch was suspended in December 22, in the middle of the third year. July, the year starts. In December, all transit was suspended. And then when I asked for the modification of the plan was kept pending. And the IBM, the central government, Indian Bureau of Mines, suspended the production in April 23. So effectively, my lord, from July 22 to July 23, two events happened. One in December 22, rejecting my application to dispatch, and in April 23, suspending my production. So effectively, I had an opportunity to mine only for 5.5 months. And the 5.5 months I've mined ore, the bulk of it is minus 45. Now, subsequently, the mine plan has been amended, allowing me to produce the 45. Whatever ore is available. No, nobody can invent ore. Whatever ore is available. Now, for that period of 22-23, they were raising a huge demand of 58 crore on the ground. You did not dispatch 55% ore, iron ore. You did not produce 55%. I said, how is it possible?
It's a natural phenomenon. If you have no control over it.
There's no iron ore, and then you suspended it, you rejected it. then how do I pay 58 crore? And then I give a detailed submission, whatever I told your lordships now, as my lord is Chief Justice is. I explain this is natural, this is the iron ore. Now, the two words in the impugned order, your explanation is not satisfactory. No reasons given. No reasons. I'll show the order. Your explanation is not satisfactory. Hence, I confirm the demand and confirm the show cause notice. On that one ground, this order will go. But this is not a speaking order. I have given a detailed submissions of all the dates, all the iron ore produced, dispatched, the rejection of the transit permit, the suspension of production. One word, not satisfactory. Two words, not satisfactory. Therefore, your lordships may issue notice.
And what if I was just really trying to understand a particular the virus when you have challenge.
The virus is the act uses only the word production. The rule uses the word produce and dispatch. Well, production is in my hand, but dispatch is not in my hand. Dispatch, it depends upon a buyer. Dispatch depends upon by me allowed to dispatch. I can produce. I have not shirked from production. Whatever production, whatever iron ore I produced, I've produced more than the minimum requirement. Minimum is about 5 lakh tons I've produced. But the bulk of the 5 lakh tons is less than 45%. And then how do I dispatch? The rule says minimum dispatch. I am challenging that portion of the rule which says minimum dispatch is contrary to the act, which only talks about sustained production and continuous sustained production. There is a vast difference between production
and the dispatch.
Dispatch. They are not eligible.
When the current act talks simpliciter of production,
Yes.
and by a subordinate legislation,
Yes,
you cannot expand
Expand.
the horizon of the current act,
that's my submission.
which in your view is offending the very core value of
Yes.
that particular provision of the current.
That is my submission. Therefore,
My
my
submission
learned
to
friends-
my lord. The two food fair that coming. One is against state for getting the revenue. Second part is challenging the virus. And they're classifying the gradation 45 or 50 or whatever. I think what the IBM is not a party to this case. Indian Bureau of Mines. And this important issue is there. If the previously one case was, I didn't remember that case. In that case, also court come to a conclusion. What is the gradation by which it can be counted?
we are not
It has already been decided.
We are not challenging.
What I am saying, my lord, let me take instruction. Let you take.
Here, that Indian Council has also agreed on that. That if the notices are issued, the counters are filed.
Before that, I am saying that let me take instruction. Then I will
Just want to have the broad view of the entire. The broad view as I gather, subject to definitely what you will say. That he is not really questioning the ascertainment or determination of a percentage of the error.
And by which that calculator will come.
This is what he says is that the error ore when it is mined or it is an extra. It's a natural thing, and whatever will come out of it is not in his hand. Now, sometimes the ores may not contain requisite percentage of the Fe, that is the 45% or 50%. It is sometimes a less. So that is what there are two buyers can buy those I don't know because it for the I do not know the
Beneficiation.
These are the things which may not be very cost effective or which may require a lot of things to be undertaken. When you use the rules, use the word the dispatch means that they have to dispatch everything. And therefore he says that once the Basic statute talks about the production, then in that case, by subordinate legislature, you cannot impose a certain conditions which are, I would say, often the very core object of the central legislation when it was enacted at some point. He says that the subordinate legislation cannot override the substantive provisions of the act, nor can whittle down its efficacy or its applicability in a particular sphere or in a particular mode. Secondly, so far as the decision is concerned, he is saying that I have given an extensive explanations. Reasonings I have already provided, the explanations I will provide. But by one stroke of pen that has been rejected, that is not satisfied.
Not satisfied.
No, it's not like that.
That's the only words.
According to him, if the order is the non-speaking order, or bereft of any reasons, then in that event, that order cannot be set into a proper order. If I understood correctly.
Yes.
That is what he submits. My learned friend submits. Yes, we'll answer.
Number two point. One would be answer, one has to be, one would be answered by the state and another,
Yes.
and the legislation is challenged, divided, then that becomes the central legislation. So both are intertwined in one.
Yes.
With tradition. Find out affidavits, there is no difficulty, and the suspension is since December 2023, so there is no.
Right.
no any evidence around. But as of now.
No, they've revoked the suspension after the plan was modified. That is the fourth year. We are only concerned about the third year.
For a moment, let's make the annexure 32. It's later of the IBM with regard to the approval of the review mining plan, all these things. And this, they have to file the return, what is their quantum. And basing on that, Indian Bureau of Mines will assess the same, then only every month it will be notified. Basing on that, state will calculate, impose the
Annexure 32 relates to the fourth year. It happened in the fourth year.
Oh, but
No. We are talking about the third year.
There is a mechanism. Let it not be, there is a mechanism to assess. So that's correct. The grade of
That
the
particular Indian Bureau of what?
Indian Bureau of Mines.
mines.
Let it's not like that. As simple as my learned senior is submitted.
What to have been included or not, only for that purpose I really wanted.
No, I have no objection to
one
include
clarification.
IBM. I am not challenging any action.
One clarification.
I am not challenging anything, any
Not
action of the
insisted to
IBM.
implement the IBM party because they raised this issue, that's why.
For the exercise.
Yes, and that's true. That part I can't control.
You can excise, or you can excise under whatever rule 82 of the city.
Yes.
Excise over. There's no difficulty.
So let them file their counter affidavits and your lordship.
If we find that.
What I'm praying, my lord, let the lordship give some time, we'll take the instruction. That on that day, lordship will decide other 40
Notice should be issued. Let
Delay the disposal.
because it is a preliminary, it's a report.
And disclose it to your stand, both of you. Then, think of that. PSG has to answer Fridays.
And this
Yes,
issue,
that's why I'm saying, let me come with a.
that is dispatch is always associated with production. I will explain, Milord. I will explain. Production.
That's the one thing.
Dispatch, it is not for the production only. It has to be dispatched. How can the Milord? Yes. Mineral development doesn't mean only production. It has to be dispatched. Look, I will explain. I am not submitting anything up very
either
now.
explain now, I am ready to argue.
No, that's
They
correct.
want to file a counter affidavit. Let them file a counter affidavit. How can there be an oral explanation and anticipation? And this very question is pending in WP 5215. notice, and then I'll make, if necessary, I'll make submissions.
What I'm praying, I'm just, let me give the shortest time. In the meanwhile, get the instruction. Then my land senior, I'll go, something is come out, then I.
You take whatever time you want from my law.
I'm placing the code, that's why this. Yes. Yes, I've taken, we can take minimum 2 weeks time. For getting
Central
instruction,
government, he
central
can't
government,
get
he
it,
can.
Your Lordship, again it would be advised.
No. At least 2 days.
The minimum will have 3 weeks, because I know the central government will not again will a time would be, my senior would be embarrassed. So it's coming from Delhi. So let it come after 3 weeks, Milord. In the meantime, let me also take instruction from the state officials. After 4 weeks in that case.
I think.
Yes, not disclosed. Yes, we will verify. We'll verify.
Earlier writ petition.
Every demand.
Challenged the virus, we challenged the demand, and there was an interim arrangement.
Whenever there is a demand, there is
Just
a
a moment,
petition.
just a moment, Mr. Advocate.
Not less than
Please.
a dozen of writ petitions by this particular violation.
It's difficult to, both of us to speak at this time.
That's correct. But
Earlier writ petition, the virus was not challenged, only the demand was challenged. And the petitioner and the respondent agreed that an amount was paid. The writ petition is pending, but there is no further interim order. In the other writ petition filed by another client, which I appeared, WP 5215, on which notice was issued, this very question is heard, this very question is raised, and division bench of this honorable court, not this honorable bench, another division bench of this honorable court has passed a detailed order recording my submissions, and kindly see, Miller, paragraph 5.2, this very question, paragraph 5.2. 5.3.
if you don't mind, can I have it?
The government advocate also appeared, paragraph 6. And paragraph 7. And then issue notice in paragraph 8. And over the page, the last page, as an interim measure, it is directed that no coercive measure pursuant to the demand notice issued by, they have not filed a counter. They have not filed a counter yet, nor have they asked for a variation of this order. They appeared.
What's wrong with the
But just a number.
This is the
5215.
Power and thinking.
I just checked it over. I can't remember, my lord. I can check it out.
I gave a copy of the order.
And Advocate General check it out. Another copy. Yes, sir, you can.
Estonia also here. Is the Estonia is something else? I did something else.
Ray, I think from the petition. She's Aishwarya Das, not Ray. Aishwarya.
General warning is that committed a mistake.
No.
My first name.
That's why I'm saying, my lord, after 2 weeks, let me keep it. 3 weeks, let me keep it. I will take instruction.
He is my law officer, not my state.
Yes.
I'll place everything on record. That is not being Lord, there is an agreement, bilateral agreement.
Same grounds are raised. Yes. Please tag it. Please tag it. I'll be happy to appeal.
But I don't think the virus is under challenge. The virus is, they say.
Yes, Manoj.
That's with regard to, Milord, that is some atomic and hydro carbon energy.
I'm sorry, Mr.
Yes,
Advocate.
12A1 in the cost
But
title,
the
it is
rule is
reflected.
called, the rule is called mineral concession
No, that's
other
correct, but
than
this
atomic
is 12A2.
mineral. It's commonly
sorry.
referred to as MCR.
Milord,
They are not
Milord, of the mineral, yes, concession rules, that's different.
It's the same rules, Ballard.
Same rule, but different mineral will. It doesn't apply here. That is a different rule. The extent is. 12A1 of the hydrocarbons. No, that's a different. 12, Milord, A1 and A2 is different. Yes, yes.
Well, earlier your lordship knows, Justice Raman knows in this state, it was called mineral concession rules. It has been amended to say mineral concession other than atomic minerals.
No, that's
rules.
correct, but
It is,
A1
just a moment, Mr. Advocate General, I beg you. Two people can't speak at the same time. It is the same rule. The same rule was challenged in 5215. 12A is the rule under challenge. There, the first 2 years, we challenged 12A1. This concerns the third year. There's a separate sub-rule, 12A2. It's 12A, but sub-rule 1 and sub-rule 2. It is the same rules. Same rules.
Rules same, but provisions are different. That's the.
Sub-rule 1 is for first 2 years. Sub-rule 2 is for the third year onwards.
The rule is similar, but the provisions are different. Got it? They shall.
This dispatch also.
Yes.
That is.
No, that's correct. That will be subject to states.
The VAT statute also constitutional identity is state version of the receipt has a particularly
Sale.
the other side of receipt of any receipt can be success. So that's that from purchase analytical.
Yes. Just for your contract. For filing counter, let's say 4 weeks. For filing counter, then I can get after 2 weeks. But filing counter, first again I am playing my lot. First me keep to after 2 weeks, I will take instruction. Thereafter, let's say after 4 weeks in it.
After 4 weeks.
Eleventh or 12th. I just not gone through it to I have to check it out. What is it? That's why it's more time.
Impugned order says not satisfactory. 1 line, 2 words. On that ground, there's any number of judgments. My lord's judgment.
Then, my lord, we have to file an objection to that. We can. He came last night at 11 o'clock. I was notified at 11 PM, right? No, that's Millard. We have to say something on the IA. We can't Millard. We pray it's a huge demand. He has Millard in some pretext is challenging in the garb of virus coming to challenge the demand. So let him satisfy that this particular person, Millard, this demand. No, everything has been followed. We'll file an affidavit. Millard, so-called personal hearing, everything has been done. Millard, it is also borne out from the record. I'll file an affidavit to the IA. Millard, let it come. I'll file an objection to the IA. No division.
276.
Yes.
Para second. According.
Para 3 Millard.
Para 2.
Accordingly, you have been so cursed, filed this office letter dated so and so, given opportunity of hearing on 25/9. You have submitted the reply on 7/10, received on 9/10 to the so cursed notice submission during hearing on 4/11/5/12. In view of the rule so and so, amendment thereof found not to be satisfactory. That's correct. Opportunity has been given. Hearing on 2 occasions he has been heard. On 4/11, I am grateful to Justice Ram.
With my own judgment and judgment of
Any number of judgments, my lord.
We have also judgments from outside. We will cite with us.
With senior colleagues on the bench.
Not satisfactory.
Exactly.
Is that a disposal of a submission and a show cause notice?
The rest is apart from that, it's also revisable, I think, section 37.
In the other writ petition also, not satisfactory. Exact same.
I think section 37. Correct, but it also be the 36 flexible.
Kindly see paragraph 5 of the earlier order, my lord, not satisfactory, and that is the same language.
We will file our response to that. What is the reply? What is the hearing? There is an agreement also, my lord, which is binding. That's
No, that is not in this case.
No,
That's a
it's there.
different case.
Mineral Development Production Agreement is there, which has been signed by the lessee with the government. I'll show you that. Let me file an objection to the IA. That's correct.
That is so. I'll tell you. No, I'm only asking, since they are taking time to file a counter affidavit. In the meanwhile, no coercive steps to be taken.
No,
That's all I'm saying.
It's
Otherwise, the
1 year old
petition will
demand.
become in.
But it's a belated application. It's revisable under section 35. He will not taking recourse to the. That's correct.
Milord,
Not entirely a person was stepping over.
I'll explain the delay.
Now the question is, in the question, what is there? There has been a quite long gap between the demand.
Precisely, my lord.
It's a May 24 demand, my lord.
Can I
Something
answer the
like-
question? Can I answer my lord's question, please? My answer is, they have not enforced the demand so far, for whatever reason, number one. Number two,
They really contemplate to impose the demand. You can definitely come and bring it.
very well. I'll say that. Yeah, I'm very satisfied with your lordship's observation. If they try to enforce the demand by coercive measures, I
Yes,
will
not
go to
the
court.
one, my lord, 3 demands are pending. So 3 demands are pending. And that too, my lord, the leftover mineral, there is another litigation around. Lord, I have to take it, gave, my lord, your lordship may.
Says that this case that considerable period has elapsed. So you have not enforced that.
Let
He
me, my lord,
says that he is now quite protected. So we say that at this stage, we are on the basis of an apprehension. You will not, there must be a reasonable apprehension or likelihood of the apprehension from the conduct. So in the event you intend to enforce.
I'll mention to your lordship.
nothing precludes someone to knock your lordship door. That is not the issue.
I'll mention to your lordship.
Lord,
Your lordships
after
are
1
here
year,
every
more
day.
than
I'll
1 year
mention to
in
your lordships.
July, he challenges a steel demand. And Lord, I do not know what is the position. The brief I was notified at 11 p.m. He might be working on it for the last fortnight. But yesterday was a Sunday also. That's correct.
He himself is saying that they have not as of now.
Let me discuss. I have not spoken to the officers. I didn't have any occasion. Also, I came straightway to the court.
I think I think your stand has been taken care of by himself. Not the was kept in presence of the party? Yes, Your Honor. It's only as they are. You could have raised it.
It,
Yes.
item 19.
To be to take instruction. The law last time court has been directing whether order has been passed or not. Lordship, in this case, order has been passed on 30th January 2025 against the so cause notice. And
Further event happened.
No,
Further event happened.
this has become virtually infructuous in that sense.
my whole submission is I'm not aware of the such order.
Why since you serve him a copy?
It may be
What's it? Even the portal also, go in the portal, if it is there, or you can also make a copy and give it to him. Order has been passed. Now you have to take a report, whatever.
I think the liberty to manual file additional affidavit.
When it will pass.
On 30th January 2025.
The REIT is also pending from 2022.
The date was filed before the order has been passed, Your Lordship.
It is against so cause notice.
Oh, I understand. I have seen the prayer. That's why I say it's become infructuous.
Yeah, let's get
The only endeavor is to save the
smile,
period.
smile.
He's given a copy. Just record that you do. Just record today it has been served, so that the invitation will run from today. Oh,
Item 20.
I mean, there are certain documents that needs to be brought on record, as well as this is an order against, challenge against the order of the ITA.
So we have to file, you know, the remedy. So how the writ lies. There has to be on a substantial question of law to be decided. As usual.
Item 21.
What?
On behalf of Abhilash,
What do you want, madam?
I want to request to pass over.
Pass over.
Assessment or the challenge test has been, the date of order may kindly be opened. Two, your letter.
Yes, sir.
Pass over.
Yes.
22.
My lord, this matter pertains to cancellation of registration certificate.
Item 23.
23, my lord, covered matter, that is in absence of GST trial.
Item number 24.
My lord, I have submitted to IA one for permission for filing of certified copy, and subsequently I have filed certified copy of the order of honorable English judge. And second IA for consideration of appreciate order.
That means you mentioned that one application of a response with application was filed and another was stayed. Here is the database they have come up. This is proper gratuity matter, my lord. Gratuity has been withheld for last 12 years. In all the first I have won on the ground that I have certain cases against me. But the section 13 is very clear for that.
No, you have filed a certificate. So, that application has become infructuous.
Yes, sir.
We first to know which IA.
18 by 2000.
Have you applied within the period of limitation?
Yes, it does. The limitation application has been disposed of on that day on 10th of allowing.
Yes.
Limitation application has been disposed of by the honorable court on 10th of this month.
When you applied for certificate copy? With the certificate copy.
I've certified copy.
Yes.
You know, certified copy.
On 2nd January 25.
Madam.
So much beyond the period of limitation. There is which. This is completed on 140. The order was passed on 9 days with the cost. So much beyond the period of limitation.
30 days.
In that period, you'll have to ask for a condonation.
They have filed, my lord. My lord was pleased to condone the bill. There was delay of 30 days. Where my lord was, yes, my lord, your lordship was
Hello.
other day. On previous date, my lord was. Yes, my lord.
Yes, is mine.
On your concession.
Yes, my lord. Because my lord, here, because of this application, they are not releasing my gratuity.
Your point with gratuity amount will not be held.
Yes, with my lord.
For whatever reason.
Whatever is, my lord, statute is very good, section 13 is very clear. If there is four things will be there.
Copy we are accepting it when you are filed. 18 has not been disposed of.
18, my lord, 18 relating to IA for appropriate order for consideration by this honorable court.
What IA, appropriate order, what is the appropriate order according to you?
Stay order against the order of single honorable single judge bench dated 9/10/2003.
What has been, and what about the IS 16 and 17? The filing of the certificate copy. This is an application seeking dispensation of filing the certificate copy of the repealed order. We have to pass a stay, we must record a very proper finding.
My humble,
What is the proper case?
my humble submission is the factual position has not been reflected in the impugn order.
What is the factual position which, if indicated, will fill the decision otherwise? Show us.
He has been involved in misappropriation of financial irregularity, misappropriation.
Have you initiated any disciplinary proceeding against it?
My,
Did you complete that disciplinary proceeding?
no.
What is the fate of the disciplinary proceeding now?
No, they have not initiated. My lord, this will be conscious while mentioning.
Number C.
Yeah.
Number C.
But that is not a fact. They have not yet initiated. They have initiated surface proceeding. Thereafter, my lord, section 68 will be, 67 will be there. 68
Space is pending.
Vigilance case.
Vigilance case is pending, my lord. But no DP.
Would it be as of now?
As of now, my lord.
DP has been initiated and it is pending.
What?
First, like,
Have
we
you
will
disclosed the
pass
number?
giving.
Have you
Yes.
disclosed the DP number?
Yes.
Yeah, I don't think.
Honorable single judge will describe everything, my lord. Taken note, thereafter judgment was passed. Yes, my lord. Yes.
Have
All
you
the-
done the-
Pardon, my lord.
Joint Labor Commissioner
So what they have held, appellate authority,
I mean,
upheld the order of controlling authority.
is entitled to a
Yes.
permit of gratuity. So show us that is there any provision in law which says that you can withhold a gratuity amount? Shows. There must be some path, some rules.
Section 4, 6 of Gratuity Act empowers employer to withhold.
Sure. So what the position? Well,
on the ground of termination, otherwise moral. Yes, I'm sorry. I'm sorry, my lord.
is it so? Yeah, please give it.
Fine.
Six.
You have not terminated.
No.
So, here, some section 6 or section 4 apply. It's a, there are some
we rely only on that provisions of,
It says whose services have been terminated. When the word terminated comes, that means it must have been terminated. You are not terminated.
no, he was allowed to
He is retired.
retire.
So what was only maybe that's why. But tell us, sir, you have the appellate, sir.
Only,
Court asking you a question, you have to.
we-
clarify.
we rely on the factual position relating to wherever he was
Let
been.
us see, sir, when you are relying on a appellate solution, you wanted those facts to be taken into account in view of section 4(6). I am simply asking because the 4(6) says that if it is already terminated, then the forfeiture can be done. I ask you, have you terminated? You say no, then why you are relying on 4(6)?
Misappropriation, series of misappropriation committed by
To
the.
be, because it was resulting to a termination. You have not terminated. Still, you have not initiated a DP, just preliminary steps before the DP can be initiated. So, how, what to do? To be stay.
One more thing may I clarify, if you also cover.
What you to
Well, because I have mentioned that, but one such a procedure was initiated against me actually.
patient for DP, that proceeding is found that you have, then they will initiate a DP procedure.
Similarly, vigilance case have also been initiated that are pending.
So, I am more on the word whose services have been terminated for a reason.
Well,
Now, it has not been terminated. And then quantifying the damages or the loss, to that extent you can forfeit, not the whole of it.
yes.
To that cheap people, details before.
Irregularities.
Right, conscious of the total. Initiated during the service period. On the ground of the financial embezzlement or financial loss suffered to the employer. Immediately he retires.
That will continue.
For the purpose of. The first is the responsibility of the land. In other cases, it will automatically lapse. But here you have not initiated the DPS. The should cause has not been issued. Nothing has been done. Is a preliminary required state. Then in that event, can you withhold the gratuity of it?
I don't think so.
So, then what wrong the competent authority passed an order, the appellate authority affirmed the order, and now the single way. CORAM. You lost. Why, as an appellate court, you will interfere into a factual aspect?
It's of serious financial irregularities.
Then why you are speaking about, sir?
Serious financial irregularity, and wherever he has been posted, he has been deliberately doing such kind of activities. That is the only.
This is the recurring nature of things many years before the retirement.
Yes.
What you were doing?
Vigilance case.
40 years. What you
Sir.
saying? Any FIR was lost?
Yes, sir. On the basis of FIR, vigilance case.
Then what happened to a FIR? Any charge sheet is filed after the investigation?
Vigilance have filed charge sheet and the case is pending. February 2013.
What can be done? We are not going to. What are you going to state? Have you?
My lord, here, well, after retirement, if service rules provides, they can proceed with me against me, the previous proceeding. In my case, my lord, there is a corporate service rules 2011, where it is absolutely silent. In one case, Honorable Supreme Court in Manari Coastal Limited, the service rules provides that they can proceed even after retirement. Here in our case, what has happened, my lord, even vigilance case will be initiated against me. Even tomorrow, assuming I will be convicted there, they can recover. There is a provision available in the statute itself. Section 67, such a proceeding going on. Section 68. Now, my lord, total amount, what embezzlement they are talking about, 1,80,000, 2,50,000 rupees around that amount. And that to one of my branch manager. He was working, I was working with him. What he has done against him also. My lord, yeah, total amount has been calculated 6 lakhs amount, 694,000 rupees. And that the interest 10% has been awarded to this annual code as well as the original code.
My lord, three misappropriation cases, which comes around 6 lakhs somehow, where he is responsible. He is, as for the audit report and such a thing, he is accountable for that. So, my lord, only
That to my lord, ground, they have not shown any perversity by the honorable single judge. Nothing has been described in grounds. The formal grounds have been mentioned, and the entire order itself by 40 pages.
if board permits, honorable court, some other day. Not.
Very simple question. Are you ready to argue the appeal of merit?
No, my lord.
When you can prepare yourself so that we will dispose of, we will not keep this matter.
1 week, 1 week. Lord.
Give us the date on which you feel that you will get to know.
2 weeks. 31st July. 31st July, if it is convenient to honorable court.
Can you come on 30th?
Yes.
My lord, I have small prayer philosophy. And what is happening there due to pendency of this appeal, they are not giving my gratuity, they are not releasing, my lord.
The courts open to you.
Yes.
Proceed in accordance with law. You have not stayed the law.
Yes, my lord, that is the case.
And 25.
The part of the pension, I think 21 lots passed over. There is not the-
55.
May it please your lordship. My lord, in this item, this was before your lordship earlier, just as a matter of refreshing, my lord. My lord, the sole moot question here is that your lordship will kindly recollect that the appellants before your lordship were initially appointed as industrial promotion officers. And this was bifurcated in the year 2017, and these persons were appointed in 2015. And after the bifurcation, this was under the micro, small, and medium enterprises department. There was another department, that is handloom, textile, and handicraft department. They were, the government decided to bifurcate this to transfer some of the employees of the industrial promotion officers to this department, to change the cadre. And option was asked, option was asked for, and in the option, the appellant before your lordship did not opt to go to that cadre, and thereafter, on the basis of the principle under Annex 4, they had decided that if there would not be sufficient number of willing employees, then it would be on the basis of junior to senior, what happened? Those there were juniors, the appellants before your lordships were transferred, and they challenged before this honorable court. And in the meantime, the new rule came so far as handicraft is concerned, and this was mentioned to the court, and the honorable court allowed the prayer of the appellants, which was submitted, that fresh option will be asked for, and they will be on the basis of the fresh option, the rule will be implemented. Thereafter, the appellant's lordship made a representation, but it was not accepted. So now, your lordship would kindly see the Annex 4, that is the at page 39, Principles of transfer, Your lordship kindly see the para 2, serial number 2, in the event of non-receipt of required willingness, the services of the junior most officers in the cadre would be transferred to the Directorate of Handloom and Handicraft and Boom Department, So this was the principle that was decided, And my lord,
What you have prayed for here in the instant writ petition, sir,
in the instant
earlier writ
petition,
petition, there was an earlier writ petition filed by you.
yes, my lord.
And this ground of this, the annexure 4, that is
Yes,
a
ma'am.
notification dated 28/9/2020, was taken into consideration by the earlier bench in an
Yes,
earlier
madam.
matter
And your lordship kindly see.
and rejected your contention.
No, my lord. Your lordship kindly see paragraph, page 26, my lord. The previous order.
Yes, it is paragraph 12 of the impugned order. The court has quoted, the single bench has quoted
Yes,
the
yes, my
order
lord.
extensively.
Yes, my lord. Your lordship kindly see paragraph 4, my lord.
Please.
3, yes, my lord. The petitioners by means of this writ petition seek to quash the resolution dated such and such under Annex 2, notification dated such and such, and the notification dated such and such under Annex 7 by declaring the action taken by the opposite parties inviting option from the petitioners without framing new cadre rules as illegal and contrary to the settled principles of law. Mrs. Patnaik, Learned Counsel for the petitioners, contended that during pendency of this petition, cadre rule has already been framed, and therefore, if option is invited, the same should be done in accordance with the cadre rule. It is also indicated in the order number such and such, interim order dated such and such passed by this court, that since the petitioners are already relieved in absence of the service condition, to guide the petitioners in the newly establishment, the service condition governing the petitioners at the time of their relief shall continue till a service condition is introduced and implemented in respect of the petitioners. As such, since the service conditions has already been introduced, the same should be implemented by the authority concerned.
That is
Mr.
what is there. So service condition has already been
Implemented.
issued.
Your Lordship, next para. Mr. H.M. Dhar.
No, he did not raise any objection. It is the
Yes, my lord.
order on concession.
Yes, my lord. That option was not asked for again. And my lord, my sole grievance, your lordship, last time formulated the issue that the juniors now have been promoted, that has been redesignated to a higher post. And I am in the lower rank, my lord, in the transport department. So lordship took a view that how can you discriminate the seniors, my lord. That was your lordship.
No, that was without reading the impugned judgment and without knowing that the earlier writ petition was disposed of.
No, my lord, I had placed the.
So it was not. So
it's all right. It's all right, my lord.
Tell me
I had placed before your lordship, but my sole grievance, my lord, is that while the juniors are retained, how, because the honorable court did not come to any conclusion that our writ application will fail in the earlier judgment, my lord. That's my prayer before lordship. And my fresh option to be asked for was considered by the additional government
transfer
advocate.
was rejected.
And fresh option would be asked that was considered by the additional government advocate. And on that issue, the matter was disposed of, my lord. And my lord, in the impugned order, the honorable single judge has not come to a conclusion that my seniority is undisputed, but has not interfered, saying that the matter has been concluded. That's the only grievance for your lordship. Your lordship may see that we are much senior in the service. Well, what happened? The juniors got a status quo order for which we were transferred and they were retained. And on the next day, they have withdrawn the writ application. The seniority position is undisputed, my lord. And my lord, your lordship would kindly see that we are BTech. And the transport post, my lord, the eligibility is BA, simple graduation, my lord. And we are BTech people, my lord. And our juniors are also BTech people. So therefore, my lord, your lordship would see under Annexure 15, which I have filed, my lord, that Annexure 15, my lord, page 77, my lord. Your lordship kindly have a look. Now this assistant industries officer, which is the new designated higher post, my lord, your lordship would kindly see that the qualification, my lord, is at page 79, item number 4, my lord. Your lordship kindly see. The candidate must have possessed BE or BTech or equivalent degree in any engineering discipline from a recognized university or educational institution of India or abroad. So therefore, my lord, we are BTech, and we have your lordship would kindly see the affidavit filed by the state government is that the new post, my lord, the eligibility is only BA. So therefore, my lord, we will have no utility in their department also. That is for your lordship's kind consideration. I have, my lord, why should I suffer if I am junior? And there are a lot of posts vacant, my lord, in the post of IPO, my lord, assistant industries officer. Lot of posts, my lord, vacant. I am highly prejudiced, my lord, because I am in a lower post and my juniors are in a higher post. Your lordship was inclined to take a view that we are not going to disturb your juniors. No notice need be sent. And your lordship would kindly consider our case.
Sir, in an earlier round of litigation, you had an option, the court did not accept it, did not permit you to exercise the option. Once
No,
the
no, my lord.
courts are closed,
Court-
then what? What more?
My lord, I may be pardoned, my lord. The court accepted the option, my lord. It has
I'm
not. He has
looking at
not
the
rejected.
authority's order. The authority says that in an earlier round of litigation, when you have accepted it, that the new policy has come, you did not exercise the option, then what is the fallout of the same you
No,
have to
no, my lord.
accept?
At the time option was asked for, new rule had not come. That is the crux of the matter, my lord.
But that was available to you in an earlier writ petition.
No, my lord. By that time, rule had not come.
Why? This was disposed of on 2021,
My lord,
2022.
my lord, only prayer before your lordship is the government accepted in the order, my lord, in the last order in the writ application, my lord. That's my only grievance before your lordship.
No, government accepted what? The new rule has come.
No, my lord, government said that Lord government advocate for the state opposite parties has no objection to such proposition, my lord. Proposition includes asking for a press option. That's what my submission to your lordship, subject to your lordship's acceptance. That is my sole submission, my lord. And in that view of the matter, these writ applications stood disposed of, my lord.
Without going into merits of the case.
This time I am not able to copy.
Only because they got a stay order.
Can you give me a nutshell of the fact from that scratch?
But initially, these petitioners were appointed as industrial promotion officer under the MSME department, that is medium, micro, small industry.
I understand, MSME, I understand.
Now that department was bifurcated to another department of handloom textiles. Now these petitioners were working under a directorate that was functioning under the MSME. Now their services were transferred, they were posted into a different cadre of, my lord, handloom promotion officer in handloom textile department. They essentially challenged that on being transferred to that particular department, our chance of promotion, because there is no chance of promotion because there was no framing of cadre rule in that particular department, and persons, those who are in fact juniors to us in our parent department, they have in the meantime got promotion and they have been, so whereas by making us transfer to the new department, we have been put in a very disadvantageous position. Now, challenging that, they approached this honorable court. What they made a submission before the honorable court that we had earlier exercised that option. So now a fresh option should be allowed to us so that we can exercise a fresh option. Now
Go back to the parent.
Go back to the parent. Now during pendency of that writ petition, the cadre rule in handloom and textile department was framed in 2021. That was produced before the honorable court. Now honorable court observed that since a cadre rule has already been framed, so their cases will be considered in terms of the new cadre rule. That is what has been accepted by this government.
Correct.
Now, my lord, now what is their grievance? Their grievance is our chance of promotion or our service condition has been seriously affected being transferred to that other department. Now, if my lords, I address the core issue of the matter, that is.
No, this cadre rule was there and placed before the court in an earlier writ petition.
Yes.
If they were dissatisfied, they could have challenged that.
Yes.
They did not challenge that cadre rule.
No.
Rather accepted it.
Yes. Your lordship may kindly see that order once again, 9/12/2021. The order, para 4 is important. Ms. S. Patnaik, Land Counsel for the petitioner, contended that during pendency of the writ petition, cadre rule has already been framed, and therefore, if option is invited, the same should be done in accordance with the cadre rule. It is also indicated in the interim order dated so and so, passed by this court so and so, that since the petitioners are already relieved in absence of any service condition to guide the petitioners in the new establishment, the service condition governing the petitioner at the time of their relief shall continue till a service condition is introduced and implemented in respect of the petitioners. As such, since the service condition has already been introduced, the same should be implemented by the authority concerned, which has been accepted.
So what they are challenging now?
Now they are saying, but they are challenging this order only on the ground. They are going back to the core issue, that main issue, that our chance of getting promotion has been, our service condition has been seriously affected because of being transferred to that other department. Now the question is, my lord, chance of promotion, consideration of promotion, and promotion. All three are three different things. My lord, consideration of promotion, your lordship knows that that may be a right, but getting a promotion, that is subject to the conditions stipulated in the cadre rule, merit, suitability, and other essential conditions. But chance of getting promotion, the same issue has been decided by the Honorable Supreme Court in three judgments, my lord, where here bifurcation, that was a case of merger of three departments. Now, what the Supreme Court said, the chance of getting promotion is not a service condition. So if your lordship will kindly have a glance to this judgment.
My lord, sorry to interrupt. Our only question is, we'll go back to our parent cadre. That
How
is
can
not.
you go back to your parent cadre? In the earlier writ petition you accepted?
My lord, my submission before your
You have
lordship.
accepted that the new cadre rule has come, and if it is implemented, I am happy. What more?
That's why my lord, the subject to what your lordship would say, but my only grievance is I don't that the new post is only graduation. I am a BTech, my lord, and
No,
I
whatever. Why you
saying-
opted to come in this department?
We never opted. That is illegally they have. My lord, my transfer is not justified, my lord. On the basis
Then you could have challenged that when you were
changed.
transferred in the earlier writ petition.
Yes,
But
my lord.
you could not emerge successful therefrom. Then I am talking about section 11 of the Code of Civil Procedure. If you have prayed for a relief and the court has not granted, it will be implied that the court has refused. Can you reopen that issue in a subsequent writ petition?
Because that was
If the plea was available to you, you have not taken such plea, then also in a subsequent proceeding, can you take such plea?
Because the my lord, I have taken such plea, but that point was not adjudicated.
Maybe that is what is there. Then please read explanation 4 and explanation 6 to section 11 of the
Yes,
Code of
my lord,
Procedure.
I am
Please read
conscious of that.
explanation 4 and 6. Rather 4, 5, 6.
Challenge what you think.
It can't be. You can't reopen the issues again.
My lord, your lordship is referring to constructive res judicata. But what I am my respectful submission before lordship is that the option was open to me. That is the honorable court allowed, my lord. That's my.
No, this is
only
what is not accepted. It is in terms of the new Carter rule. If the option is not given, not given.
But my whole dispute was with the transfer done. And the issue was not finally and substantially decided. Finally,
My lord, the issue of transfer was not decided. That's my respectful.
Sir, then explanation 5 comes. A relief claimed in the plaint, which is not expressly granted by the decree, shall, for the purpose of this section, be deemed to have been refused. If in earlier round of litigation the relief is not granted, then it will be deemed that it is refused.
My lord, my submission before your lordship is there was a positive observation that fresh option will be given, my lord.
No, it was your submission, and then the court has said that yes, new guideline has come, you implement it. If the new guideline does not talk about the fresh option, then you have foreclosed your right. You could have challenged that order. That there was a wrong recording of the submission. I never made such submission.
because without card the rules
This cannot be done.
मैं आपको judgment देखेगा लोग judgment so करिए will show one judgment lying on this.
My lord, can your lordship, will your lordship
No judgment, sir.
Will your lordship give an opportunity to show certain judgments that my respectful submission before lordship is that my prayer has not been rejected, not hit by res judicata. As your lordship should kindly please.
Sir, please look at paragraph 3 of the earlier order in an earlier writ petition.
Yes, my lord.
First thing is you want to quash the resolution dated 20th of August 2020 under Annexure 2. Then you wanted to challenge the notification dated 28/9/2020. And then the notification dated 29/10/2020 by declaring the action of the opposite parties, inviting option from the petitioner without any new cadre rules as illegal and contrary to the said principles. That writ petition has been decided. What you have made a submission that during the pendency of the writ petition, cadre rules have already been framed. And therefore, if option is invited, the same should be done in accordance with the cadre rule. So that cadre rule must contain an option to be exercised. It is also indicated in the order, interim order passed, that since the petitioners has already relieved in absence of any service conditions to guide the petitioners in new establishment, the service condition governing the petitioner at the time of their relief shall continue till the service condition is introduced and implemented in respect of our petitioners. Then is the very catch. As such, since the service condition has already been introduced, the same should be implemented by an authority concerned, which they accepted implementation. Show us that this service condition contained an option.
During the existence of service condition, I'm going to come here. B.Tech instruction, I'm decaying.
It's not.
मैं देखिएगा कि डॉक्टर कोटे अच्छी बोली. This has become infructuous ना इतने cadre.
That was only my submission, my lord. No, as your lordship should kindly consider that my injustice has been done to me because my juniors are getting higher salary.
That was your juniors who remained in the parent department. Now they have been put into that cadre list.
Now they are in the similar position.
Now there is a separate cadre list for you.
That is what my challenge before your lordship.
But this was available to you, sir, when you filed the earlier writ petition in 2020-21. This was available because those were the scenario of that time. You had that right. You could have said so.
My lord, my submission before lordship is it was not adjudicated. That's all, my lord.
Then explanation 5 will come in your way of section 11.
My lord, since the learned government advocate has agreed to the proposition, I had no grievance, my lord, so far as transfer is concerned. I thought that they'll adjudicate afresh, my lord.
Because they
No,
accepted
No, sir. No, sir. No, sir. The question was the introduction and implementation of the new cadre rules. And that is the new service conditions.
Will your lordship see the proposition your lordship was inclined to formulate in the order dated 15/5/2025?
Yes.
15/5/2025 order, your lordship kindly see, order number 1.
At that point of time, sir, it was only the submission which was advanced, so we made a point. But now, after noticing all the document, now this thing emerged.
They have also withdrawn their writ petition, na?
We did not notice that you have accepted this position in the earlier writ petition.
My lord, once your lordship says that I have nothing more to add, my lord.
Yes.
But my understanding was that my option was accepted to be exercised, press. That's what I got the impression.
Then we'll have to write.
They have also withdrawn their writ petition.
And My lord, they have also withdrawn the writ petition.
They are also
And
supportive.
they are now in a higher pedestal, my lord. Juniors. I am, injustice has been done to me. That's what only your grievance before your lordship.
Yes.
My lord, can I submit, my lord? My lord, if my lord will allow, my lord.
My your lordship may allow my learned friends to make one submission, your lordship may allow.
Yes.
My lord, the opposite parties, they have also preferred the same writ petition, challenging the same resolution. And later on, they withdrawn this writ
So
petition.
what that is their decision. They found that the submission which is advanced is beneficial to them, so they will not proceed with the writ petition because that relief has been granted to them.
My lord, that is not their relief. They have also challenged the resolution.
Oh, madam, then one can abandon his right. He can abandon his claim also. They abandoned their claim. That does not mean that that would be going against them in that way. They decided, I do not want to pursue my remedy because I think that order has taken care of my service, which in fact has been taken care of.
My lord, they have been transferred without any cadre rule at that point of time. And when cadre rule come into existence, this writ becomes infructuous. And they have given us an opportunity in the representation. That representation got rejected, for which the present writ application, my lord.
So representation is based upon the observations made in the earlier writ petition. I have gone through that representation.
My lord, they have said that only since they have obtained the stay order in the earlier writ petition, so they could not consider our case. That is their finding.
No, they relied upon that particular order passed in your writ petition. And they have gone that under the new service conditions, there is no option for repatriation to the parent department.
My lord, 57.
You have repatriated some of them?
No, my lord.
No.
You have not repatriated any of them?
No.
The cadre rules, the new cadre rule for handloom organization, that that is already a part of record in.
I understand.
Yeah.
What
there
I
is
understand.
no such.
Whoever was transferred to a handloom department on the basis of they have not been repatriated, not a single. That's all.
Only two of them are there, my lord. Only two petitioners. Only two petitioners, my lord.
What?
My lord, who wait to be repatriated.
No. Everybody has been repatriated to the parent department.
No, my lord.
Not a single repatriation has been done. So you can't take advantage of a discrimination.
My lord, only that para can I read, my lord. Only that.
No, you have read it. We have read it. Your senior has referred that paragraph.
At page 57.
Yes, that is the observation of the court.
Only that since they have obtained status quo in their favor, for which fresh exercising option holds no merits. Since they have obtained status quo, this is the finding of the opposite party.
They were not transferred to a department. They remained in the parent department.
Because of the status quo.
You exercise your option.
We never exercised our option.
Or whatever the transfer was affected, then what remains? The new cadre rule comes, they say whoever is come will be governed by this. They remain there.
My lord, can I request, my lord? My lord, under such circumstances, there are posts are vacant, 100 posts. If two petitioners are there, if they can be considered, my lord. Because this is a fortuitous circumstances, my lord. Since they obtained status quo, we could not obtain status quo at the relevant time.
They are very much, I would say, aggrieved that those who were also transferred, approached and got the status quo order, and they remained in the parent department, and they were a very obedient, very disciplined the employee, they accepted your order and went to another department. Later on, they remained in the parent department, now they are
What is that?
made to suffer.
But they are
This
not
is
the,
their whole
they are not the only two. And the writ petition where the order was passed earlier, there 13% they had approved this one.
Please understand what they
Yes.
say. You could not bring them. They remained in the parent department. They withdrew their writ petition. You could not enforce that transfer to come.
So all have come. All have come.
Those
How
who
can this-
withdrew their writ petitions were also transferred.
Yes, my lord. Because of the status quo, initially it was not carried out, but
So they
subsequently.
got that this is what the entire set of the transferee. Even those who obtained the status quo order after withdrawal, they came.
That is not their case in the writ petition. Hello. They are making this submission, let them put it on affidavit.
So what is this? Again, it will be quite a.
But that is not the submission.
No, no.
And moreover, under the new cadre rule, they have the option of getting promotion. Accordingly, it will be considered if they are found suitable and meritorious, whatever.
Yes.
My lord, as per the cadre rule, when we were not supposed to be transferred, my juniors has to be transferred. And because they obtained the status quo, for which they remained in the parent cadre, and we got transferred to this new cadre.
What she is saying.
My lord, and we all have filed this writ petition at the same year. And our writ petition got disposed of, and they withdrawn their writ petition. Now we are all on the same footing. Since they have obtained status quo, they remained in their parent cadre, and we got transferred to this new cadre. And we have challenged that transfer order.
MBA and BTech.
But that is not the case in the writ petition.
Yes, my lord, this is the case of the petitioner, my lord.
Okay.
My lord, their finding is also based on that, since they have obtained the status quo order at page 57.
How can it be? So everybody has to come here.
Yes, my lord.
Yes, why you did not implement? Anyhow.
Has passed an order. That order was essentially accepted by everyone. Then subsequent writ petition is also not maintained.
Item 26.
Fine.
Well,
26, my lord, I am appearing for the appeal. My learned senior has filed objection to the IA for amendment. I had filed one last objection.
Amendment. Objection?
They had filed in, they wanted to withdraw some of the admissions which were made. So we were given a chance to file an objection. to that.
That case where I have done some effects because of taking some paragraphs from my seniors.
Wait, that's simple.
3094. But email.
What was your stand in the WP? Was it the same stand?
WPC, the first WPC man.
Where, from where you got it? From where you got these
From the
words?
second read petition. From WPC, the impugned order which is annexed, my lord, that read petition. WPC 43100.
Yes. What do you say that they have borrowed your writ petition?
We have literally borrowed it petition. If in fact, while preparing this objection, we saw there are many other paragraphs. If all those paragraphs are gone, there's nothing left to be adjudicated. Not even the background, not even
There is
ground.
parts. We have already, my lord, in this court, we have discussed regarding this several times regarding the words that are used. But my case, last time also I submitted. If this IA is allowed, then I will file the consolidated cost title. If this IA is not allowed, I am ready to press on merit. I will stick to my prayer, I stick to the judgment. That is also objected by my senior that I
Yes,
that I cannot submit from the.
I should know what case I am supposed to defend. If I do not know the case I'm supposed to.
Sir, I will not go to the facts and merit. Sir, there is a conceptual wrong, maybe procedural wrong. I will not even go to the paragraphs or a submission of my learned senior. My only question is that if one writ petition was filed and a direction was given, then can a second writ petition be filed to seek quash of that quashing of that direction in the first appeal? And subsequently it's getting quashed, then that writ petition is getting allowed, the second writ petition. Sir, I researched on this matter and several decisions I found that for second writ petition is only maintainable if to give enforcement to the first writ petition, not to set aside some direction, sir. So that is my major prayer. Then there is second, third point also.
The second, third point.
The second, third point is a civil remedy was also there so that they can could have approached the civil authority first, but they did not. And number 3 is regarding the paragraphs that are there. There are certain things that my learned senior, with all respect, the certain things that has been acknowledged that this in the first writ petition, these directions were given, and in the second writ, these directions are not to be taken into considerations. But the connection of first writ petition, second writ petition is there. So first writ petition's order was not completed, sir, not over. The pendency, the direction that was given, it is still pending. And in the second writ petition, it is filed for the prayer being that to set aside the registration or to consider the registration. In the point C, it is written to quash the order, the direction which was given in the first writ petition.
That is quashed.
That is quashed.
So the impugned order.
The judgment.
Last.
Paragraph 41 onwards.
Lordship, that's actually not the case. Para 43 is the impugned annexure in the second writ. Lordships, let me explain, your Lordships. Para 43, yes, your Lordships. Para 43.
Where it is into the form that the earlier reposition the court has not decided properly.
Your Lordships, the earlier writ application was disposed of in the first date without any notice to any parties.
The findings have been made in the earlier reposition. That is exactly what.
Your Lordships will see. Para 43, para 43.
Page cannot act as an appellate for.
No, is para 43 what your Lordship says?
Yes, court find the outcome of fraud, then and then only.
Your Lordships are pointing on para 43. 43 of the judgment. Thus, from the above narration, a fact is seen that the concerned state authorities have dealt with the issue in a somewhat haphazard manner and in a case contrary to the provision. The entire action therefore becomes unconscionable and law warranting interference by this court. It doesn't say anything about the earlier. We, in fact, our case in the second writ was this: that if the orders of the earlier writ had to be followed and a TLD proceeding was going on and it had not been completed, then how, at the behest of these appellant, a second registration proceeding started? Because a 12D proceeding is a proceeding for cancellation of a registration certificate. These people who are not the office bearers went and filed an writ application, took an order from the court that let the 12D proceeding happen and no election happened to the office. While that proceeding was going on and this society and its members were participating, suddenly a re-registration of the certificate happened showing them as the office bearers. That was the impugned annexure and that was quashed. Therefore, the court in fact relied that if the earlier order has to follow its logical end, how did the state authorities on whose application did that? And the re-registration of the certificate, the court found does not of the same society. And this re-registration certificate, that concept is not there in the society registration rule. So they found that they have acted without jurisdiction.
That was there. We in fact,
What was CRC?
only one line order, your lordships, that your lordship will find on the writ which is there.
So it's an annexure to page
One-
15 of the report.
138, your lordships will see, of the writ, of the writ.
Page 18 of the writ appeal.
Your lordships will see WPC number 431 of 2023 has been annexure. Your lordships page, no, annexure. Page 138, if your lordships will come.
It's appeal of the year.
Yes, 15, yes, it's part of annexure 15. It is part, we've also separately annexed it.
Sundari, appeal it is an actual, at page 21 it is there. In the rate appeal. And it starts from page 18, but the order starts from page 21.
What did we say is the justification? Complaint under being considered and disposed of within a time. What does it mean? Nothing has been decided.
Yes, your lordship, this
If the
annexure,
decision is taken,
Taken.
no election of the committee will be taken.
this annexure 3 was a 12D application filed by them.
Correct. So that has been disposed of.
No, that's the case. When it was
There-
pending, the
there won't be
impunity.
any election of the executive government.
Exactly, your lordships. Then how did they come up with this new
No.
certificate showing themselves?
No.
They are abused
How
both
you
process
become
of court and the machinery.
I use the word, you become swearbook. Oh, who obtained this order, I believe?
Yes, sir.
Yes.
Sir, but there is a
If that is the procedure, if the fact is that till date that addiction 3 has not been disposed of by the authority, then the operative portion of the order which you obtained is still the decision is taken on addiction 3. No election to the executive committee or municipal chambers of commerce shall be undertaken. So how can the election be undertaken? I'm asking. How?
This year.
Tell me. How?
Sir, in the judgment, at paragraph, some relevant paragraphs, 12 and 14, where not just 12D, there are other proceedings also.
Sorry, when the earlier expedition was disposed of, it was only an annexure 3 series. That is the 12D application. And it has not been disposed of. How can you claim?
There's not been,
And this is a new society you have claimed.
no, my lord, the appellant,
If you say not a new society, then how you become an office bearer?
sir, in this, the discrepancy is in deep. That is why the case should be adjudicated in that manner, in that
Sir, I
court.
am asking you a merit.
Sir,
Tell me,
sir, this,
tell me. Then
sir, the society,
what challenge you made there? This was a restriction filed by
Lordships.
for watching this particular
Annexure.
certificate of registration.
Annexure 20.
Let us see how they play that they have become.
Yes, your lordships. I'm sure they're. Your lordships wants to see annexure 3, which they have.
At election 20 to the.
Yes.
Certificate of registration.
And your lordships will see they have claimed themselves as.
September 2023.
While the 12D proceeding was pending.
Still pending, you are saying?
Yes, that's also what the court has held in its judgment. That's an admitted case of all the parties. All the order sheets, everything was produced before the writ court. And your lordships will find at page 29 of this writ appeal, they have claimed that
Versus kind of that petition. In complex, we understand the desire of forming a society. So this is a new one.
yes,
This was the government about people and believe, and then they wanted the same name.
same name, same earlier registration certificate.
Can be given by the registrar of society. This is the, how your registrar of society can give a, how? Society is already registered.
Yes.
Certificate is pending. How can give it?
I'm at some loss because the petition is not there. I was looking for this.
Let them form a different society, no problem.
No problem, but during financial proceeding.
But with the same name,
Same.
under the society registration.
There is a bar here.
There is one.
The society,
They
the society was started by the appellant number one's father.
Sir,
So the moment,
It becomes your
no.
vested property.
No, sir. Sir, that is not the fact. The moment he died in 2019 or 20, sir, there was 5 internal problems between the son and his followers, along with the people who were seniors. Sir, after that, that dispute happened. And so, at that behest, when the current writ petitioners, the president who was there elected by himself, they started to
So with the.
create a-
If they have wrongfully, illegally.
Sir, sir, it is not only 12-day applications.
Will take care of that.
Sir,
How will do this?
so we have applied for the cancellation of their registration also.
That will be taken care of. What's registration? That's the original.
Sir, that's the only time registration. There is no election ever held. No, nothing.
So, yeah, hold the election, there is no difficulty.
Yes.
If you have a majority member, fair enough. But it's not your ancestral property.
No, it's not. That is not my. That I have not taken.
That is what appears to be. My father has created, so I have all the vested right.
No, sir. There was. I am not able to. Sir, I am not able to explain the amendment, but there was an amendment in respect of that in the year 2021, sir, they have to do a re-registration because they had never, after 1993, nothing has been the renewal or anything.
The proceeding is pending. No election could be held, now the proceeding has to be decided. It will remain in I would say in abeyance or in video or in limbo, I do not know. Society will remain.
About the statement made by Lantern, it has been reflected in the impugned order at para 18, the stand taken thereon. At page 64, your lordship will find about 10 lines from the bottom. Page 64. The society registered earlier by the additional.
Society Registration Act. Actually, so these are must have.
Yes.
No, sir. And the court has passed.
Only that in new certificate which came, and in fact, your lordship, we had filed an affidavit another day. Some people who had signed there, that new form, have said that it was taken under misrepresentation of fact. So, I mean, and so your lordship, actually, this society is responsible for film distribution of all the Odia films in the state.
It's a very highly reputed society. And
Paragraph 17, 18 of the judgment.
if your lordship will permit, I'll show all the relevant rules and provisions and amendment, and also the relevant portion of the paragraph judgment.
One after another,
Yes, sir.
I see 12D.
12D, your lordships. Your lordships, then your lordships, I will show also section 1, because that is what they had also pleaded. Odisha amendment. If your lordships find the Odisha amendment will be there. Must be page 6 of that book, because both the books are same.
Yes.
The state government may by notification appoint a person to be called the registrar of society, and he shall exercise such powers and perform such duties and functions as are conferred by or under the provisions of the Act, and shall be subject to general and special order as the state government from time to time makes superintendent. Yes, your lordships. They argued, that was the argument, because this different distribution of power has come, therefore all the registrations, all the certificates require a re-registration. That was one of the stand which state took. Then your lordships will see para 1A as to how a society is to be registered. That how you have to submit a memorandum of association. It's a new, when a new society comes up. Then your lordships, what they pleaded against us is section 3, again Odisha amendment, which my learned friend was trying to place. Upon your lordships, it's upon the memorandum certified copy filed on payment of fees may be notified by the government from time to the registered society shall certify in hand the society registered in this act. A certificate of registration issued. Yes, your lordship. This proviso is there. Previously, it used to be lifelong. So now it's limited to 5 years. Provided that a society registered on this act before the commencement of the society registration.
So 5 years.
So
Certificate not live.
yes, so my certificate is alive till 2026. This amendment came in 21.
Renewal or extension.
No, your lordships, no, after this, after 5 years or completion of 2020, I have to renew. And the renewal. No, it's still there. Your lordship, I'm still valid till 2026.
I understand.
Yes.
I am asking that it talks about the limited period of 5 years. Thereafter what?
Your lordship,
There is a process for renewal.
3B.
Another 5 years.
Yes, and your lordship, 3B4 is very important, but that's also the court took note of. The registrar society may refuse to renew a certificate of registration. Yes. Yes. Your lordships, there were some rules that book may not be having the rules, your lordships, but they were part of the writ. Yes, your lordship. Your lordships will. With the rules.
Yes.
Read file.
I'm holding.
Read file. Read file.
You can hold it. Very good. Lordships, the records of the writ must be having it because we had handed it over. See, no, I tell you this last week. We can write that.
Odisha Society Registration Rules 2023. Odisha Society Registration Rules 2023. Good thing.
No, Your Lordship, that was also there. The rules are also given. Probably part of our written note there.
That is the everything. Notes of argument, brief notes of argument, additional notes of argument. Where? Got it. Which rules?
Your Lordship will see rule 3 again is that conferment of power. And then your Lordship will see thereafter there would be rules how a new society has to come. And 7. And this certificate has been issued under 7, rule 7. The certificate itself shows that. Because they have forms for it. Then your Lordship will see there must be 8, talks about amendment.
Each talks about the renewal.
Renewal. And that renewal, and that how when a renewal is required and you've not done it, how you'll be notified also. And then also there is 9 probably which talks about if you want to make some changes.
That is the amendment.
Yeah. Yes.
Managing body rules
Yes.
of the society.
Because the state pleaded that we are doing it in view of 3 and 9. So moto. They did not produce whose application you acted upon. And they said it is re-registration. Re-registration is a concept your Lordship will not find in the act in the rules. But on the face of it, it shows 7. And it can't be a new society. 7 is only for a new.
Registration cannot be done.
Yes, your Lordship.
Is it amendment that can be done or renewal that can?
That's precisely what the single judge held, that the power which was exercised by the state machinery was without jurisdiction. And therefore, it is not about an inter se conflict, but it is how did the state machinery exercised it. And also it stated that when the 12D proceeding was there, you should not have touched the certificate in any form. You should have allowed the proceeding to happen and take it logical end. Because your Lordship, section 3B itself says even a renewal cannot be allowed if a 12D proceeding is there. So that was all the case. That is exactly what the single judge has adjudicated.
Yes. Yes. Now I'm very. Forget about the amendment. Forget about the.
Yes, sir. My ground was mainly depending upon the fact that the first expedition's order should have been attained finally
No,
in order to.
they are saying that how can you get those, this society, the same way the society will think in register, the provision of rule 3 and rule 7. When you yourself, I think yourself went to the court and obtained the order.
First part I didn't say, I humbly pray if my Lord will give me some time to address this.
Say not merit, I am ready. No, the public will for merit.
No, my merit, I was,
Please do not go
sir,
by
my
this.
merit.
Now we have invited you on merit. Argue on merit. These are the facts. 12D proceeding at your behest is pending. Interim order, no election till 12D proceeding is decided, obtained by you. Now this appears that you went and got yours, this particular society registered, which is the same society. Now tell me either it's a fresh one, then can it be done? Can it be done? Yes. Okay, sir. Hearing the prohibition. What's more? No illegal.
Sir, if my Lord will give me a bit time to examine more, because
More.
little bit.
What we were doing here.
I was.
When a court express his intention, which is not in your favor, you can't. That's-
My submission also was limited to this. If at all I have a case, I'll try to explain regarding the relation between the first hit and the second hit.
It's not just,
If there is no hit, then I don't. Then I don't want to.
Really over around the city.
Then I don't want to bother my city.
Because the first street or the second gate which was there, it was only that you will do election. We have not cleared the election. Now you went there and got a new society registered, which is, the prohibition is apparent under rule 738. Like a copyright or a trademark, one cannot get the same name or anything which is similar. How can you get it the same name? And sir, what the society will register done?
The stand taken before the honorable single judge. It is reflected in para 19.
But the law is very clear.
I understand.
So,
Thereafter, after the judgment was rendered, we have not filed any writ appeal. We have accepted the judgment.
No, sir. One. One. Has to go. And we do not find any login. We
For example, that they have applied for re-registration, they will be granted liberty to file a new society with a new name instead of.
Where is the bar?
That is that.
Where is the bar? If a society is registered, say, in the name of A and B, then sorry, if you want to do it in XYZ, it is up to you, freedom is there, who prevents you?
If that part
Who
is
can
written,
prevent
if
from-
that part is written, then the client.
Oh, sir, we can't. Why are you doing the liberty? That's the right. Sir, imaginary name, we don't know, and then grant you a leave. Anyhow.
Item 27.
Yes.
Item 27 is what is. Senior advocate to Ashok Man is for appearance. But it's on and number 6. There's a next piece. I think the first match.
No. What is the matter about? What is the other side?
Here, the INCO has preferred appeal against the authority of single judge
Regularization of a service.
relating to regulation of service.
Denied.
It has been in fact allowed, my lords.
Then why you
But
are
the only
challenging
thing-
the order?
My lords, the INCO has challenged only on the ground that the date of regulation, which has
Should
been,
be from a retrospective date, not from a prospective.
no, my lords. In fact, the other side, my lords, contrary.
It should be from a prospective date.
Prospective date, which has been done by the honorable single judge retrospectively. That has been challenged.
You are,
And for
who are you?
INCO, for INCO.
Oh. I thought the writ petitioner.
But petitioner have also preferred the time, the second subject.
Right.
Second subject, your lordship, my financial benefit has been denied.
Financial
Against
benefit,
that also I am.
No, he is asking for completion after completion of 6 years. That's what is.
yes.
So financial benefit from the date of initial joining.
No, after that is the condition, after 6 years of contractual service, then my services is to be regularized.
Correct.
But they have regularized my service after 13 years of service. So
So
my
you are entitled to
My lord,
from
that-
retrospective date.
retrospective date.
And the
That
regularization has taken place from which date?
that is in the year 2020. But my claim is from the year 2013, because I have completed 6 years of service. As my counterpart also, those who are in the government, they have completed that.
And they have been granted
Why not? They have been granted.
from 2013.
13, that is the term and condition when government issued that circular, but there is a condition that after completion of 6 years of service, the services is to be regularized. Thereafter, another circular is issued that seniority is also to be counted.
From the date,
My lord, after completion of 6 years of service.
of the date when you completed 6
6
years
years
or
of
when you entered
No,
as
that
a
is
contractual.
After
No.
completion of
Completion of
6
6 years.
years.
But even then.
Now, the only issue, if I may praise the lordship,
All the
that lordship may kindly see the regulations, the part,
what it's
relevant part is at page 32, my lord.
Yes, what it says.
My lord, it says that for the purpose of promotion, my lords, a person must have put in 5 years of service in the feeder post or grade so as to consider him or her suitable for promotion to the next post or grade.
That is a promotion.
Promotion, my lord,
It's a
yes.
question of regularization in the feeder post.
Feeder post. Two prayers he has made. One is regulation, another
Forget
is
about the
promotion.
promotion. Now at the feeder post, what?
Feeder post, my lord, prior to 2019 regulation, my lords, there were no cadre, my lord, and he was not born within the cadre of the ITCO efforts. He was on, he was conducting as
your
contract.
existence is from 1981, if I correct.
My lord.
Then how those employees were treated?
My lord, they were, he was engaged on contractual basis and an agreement was also executed with ITCO. If the lordship may see the agreement annexure 7, there are also certain terms and conditions.
On a contractual basis.
On contractual basis, my lord.
All.
Not all, not all, my lord.
Well,
Not all, my lords. As petitioner on
regularize these surveys. Under what
that-
provision?
that is the only issue, my lords.
You have a separate legislation, you have a separate regulation. And in that event, how you regularize the contractual side?
And you following the government's.
If it appears that you follow the government, then you must follow with all compliments, not in a peaceful or segregated. Why I am putting so much of question is for this.
ITCO has to also obtain approval from the government members. 2020 also, my lord.
Everything has been given, sir. Everything has been given. How can you? That is what I say. When you say separate legislation, separate regulations, I am guided by my own. Then I was inquiring where from you got the power to regularize this.
The ITCO's power, my lords, only.
And from the date when the other government employees have been given all the benefits from the date when they completed the 6 years of service as a contractor. How can you make a distinction and deprive?
My lord, the honorable single judge, my lord, referring to a transitory provision that is provided in regulation 37 of this ITCO regulations 2019. And so also, my lord, referring to a circular of the works department has directed for retrospective regulation. That is challenged because that circular and the transitory provision has not been interpreted properly, my lords. Because, my lord, the transitory provision provides
What
that.
is the stand of the state? The state has taken that in his organizations, he has given benefit from 6 years.
Completion of 6 years of service. Completion of 6
Actual
years of
benefits.
contractual service.
Actual benefit. Then how can you?
That is the only issue, my lord, the limited
Then how
issue.
can you?
Give it to your lordship
How
consideration.
how can you divide the state?
The lordship may keep that the order of the honorable singers is intact, that is fine, my lords, but the financial benefits may not
They
be.
have to because they have already extended.
Financial benefit only I object.
No, sir. No, sir. How can you deny when his right get fructified?
But
Then in that event, he is entitled to all benefits from that day.
no,
How can you deny?
really, my lords, it is regularized notionally, my lords, but for the purpose of
The government
other
has said
benefits.
that's why I asked, what is the stand? The government has not given a notional benefits. They have given an actual financial benefits.
In this particular case, we have not filed a counter, but that is stand taken by the government.
Government not.
Yes, sir.
Not necessary, that is the stand he has taken. Yes, we have uniformly given to all the government contractual employees income. And if the treatment is there, then you are not a.
No, in fact, in service also, he was getting all the financial benefits. Only thing that when
Regularized employees.
Well-
Now, as a contractual, there is a remuneration or a consideration. But once he becomes a permanent, then
Well-
all benefits is in that.
the honorable single judge has in fact in the last portion of the order observed that with the direction to the opposite parties to grant all such service benefits in favor of the petitioner to count his service in the regular establishment for such other service benefits except financial benefits. That is,
But yes, so
he is not prejudiced, only that period of.
His privilege is not the financial benefit. That means a notional for the purpose of computation or at the time of retirement, the pension, qualifying service. this will be treated or counted. He is not getting it. Is it IFCO?
IDCO, my lords, industrial,
IDCO,
industrial corporation.
Industrial Infrastructure Development Corporation.
So, what is his designation? Post.
Junior engineer.
So why you are depriving your junior engineer?
No, he has not been deprived, my lords. He has been already regularized. We took it from 2020, my lords.
You have not given it to him. I think that is the biggest deprivation.
No, so far as that financial benefit lost by grandson, I will see some decisions. My lord.
It is again a policy decision, I tell you. When a government has taken a policy decision to regularize all contextual employees after and paid the entire amount, and there is no question of any segregation.
No, let the government take a decision in respect of the
They
petition.
have already in respect of competition. Now you say that now he is entitled to this, please, because they are funding or you are the self autonomous body who has a self income.
Some percentage government has got some players.
Industrial department is clear.
Administrative department, industrial department.
Yes. So they will pay. What is the difficulty, sir?
Because in the petition, my lords, he has paid with effect from 2013, my lords. So that
When
also be
6 years
considered, but
expires.
my lord,
He's claiming from 2013, he has got it from 2020.
2020.
7 years
7 years.
period. He gives for 7 years period.
Lordship,
The government will pay you.
Lordship, recording my submission, Lordship may dispose of.
Sir, you will do it. We're just trying to understand.
Well,
Yes. That's your stat that all the government is going in the similar circumstances.
Relying on
Actual monetary benefit from the day when they completed 6 years.
As a matter of fact, that was not was stand initially. It came through various court processes. It went up on Supreme Court, came back from there. Thereafter it is given.
C.
Group C, Group C.
Group C.
Group C, your lordship knows that.
Group C, Group D rules.
Yes. 2013.
2013 contract.
Your lordship possibly has rendered a judgment sitting in some other division bench. Yes, I remember. My lord, Justice Raman has already rendered a judgment. My lord, Justice Raman has already rendered a judgment sitting in a different division bench on this question of law.
But not this organization.
This organization, I don't say.
Substituting to repeal age. 2020 repeal age.
Same treatment, sir. What can we do?
Well,
Or you convince my brother to take a dissenting view. What is dismissed? That is
Where are your appeal?
Not hearing you.
I'm extremely sorry when I said called in the other court.
Record the name.
My lord, item 21, that is passed over value.
Yes. What is that?
Here the assessment notice on reliance. We pass without complex natural justice. My lord,
33, right?
Item 33. Yes.
That order. We have already. You are ready. Since it could not reach, so tomorrow will.
My lord, item number 29. No, madam. On behalf of MC Das, kindly taken off next week.
speed post. Held regulatory and RPAD expansion registers.
But beyond that,
Accepted and procedural.
yes, whether it is listed at the behest of the department, because
Item.
you have submitted the requisites out of time. So we are accepting it. And then the office is directed to effect the service.
29.
29.
48 is the last sub-item, WPC 14119 of 2025. On the last occasion when your lordship passed orders, instead of passing your lordship the interim order, it was only adjourned today, your lordship. Interim order may kindly be passed, your lordship. 168A, the recommendation of the council. Item 48, your lordship, the last serial, 14119. I have filed an IA to that effect also. It is a flat lead. There's an order, but that's
48.
48. Last serial.
Is a batch of
The last serial, the
concerning what?
yeah, this is 168A of the GST Act, your lordship. Recommendation of the council was not present.
We will consider, we cannot pass an order with this.
Lordship will call it tomorrow.
Let us.